Duquesne Law School. Practiced my dad's brother in Smithville for 12 years. They're still there. And
What made you come down here?
12 years working with family.
We're gonna get started.
Never get the job elsewhere, this kind of thing with my wife. She got a job here in Baltimore.
Very nice.
I took the out-of-state attorney bar. And I haven't looked back since then. I absolutely love it.
Yeah, I grew up there. And I tried University of Maryland for undergrad.
I don't want to be there. I'll take too much time.
I still have friends there, but I go back like that. I see you.
I need a whistle.
Which?
All right, everybody, thanks for coming to this. This is actually the second annual Family Law Cohort. The first one was successful, but we learned a few things, and we're doing this just a little bit different. I'm just going to take about 5 minutes to go over a few things in your packet. A couple of things I've added. You'll see in the first part of your packet on the right-hand side, there's just a general mentor and mentee letter welcoming you to the program. That's just there for you to read at your own leisure. Underneath that, you will see mentor and mentee expectations. This is a new addition to the program. The reason I added these is, and I'll tell you the main problem we had last year, not with all attorneys and mentees, but with some, was an inability and a lack of regular communication with each other, to check on the cases, to make sure you're in the right place in your case, and just generally stay on top of your cases that you will ultimately be assigned. So you'll see here, there's a part on client contact and initial consultation, the file review, ongoing communication, and case ownership for mentors. And mentees, you'll see pretty much the same thing, but there may be some differences to that based on the role that you're playing here. I'd like you to read these in their entirety when you can, and get familiar with those sort of things. Your cases will be assigned in the next couple of weeks. I do have one case that is ready to go, but I want to wait until I get a few more. When that happens, you'll get an email individually of what the case is, and what we will do is have you check conflicts, both mentee and mentor, and let us know if there aren't any conflicts, and if there are not, we will send you the file. We will send a file to both mentee and mentor, and however, the mentee is a primary attorney on the case. The mentor provides the advice. Mentee, mentor. Did I get all that right? I think I did. Okay, so just keep that in mind. Any questions, please feel free. Is this Edith?
Lucille.
Yeah. Oh, Lisa.
Apologies for being late.
Oh, no, that's all right. Everybody was kind of.
And the traffic was bad. Make yourself comfortable and then please help yourself. We just started.
All right, so keep in touch with each other. Look out for a new case, and we'll advise you when we get it.
Quick question. So the mentor enters their appearance in the case, and the mentee, the mentee enters their appearance in the case, and the mentor follows everything that the mentee does, correct?
And advises.
Yes, but we don't enter.
You're not actually handling the case, and you will not be listed on the listserv as on the legal server as the primary attorney. It would be.
But if they go to court, we would go with them.
Yes, correct. Correct. Got it. Here's something new we added. And I really encourage you all to let me know if there's any changes that you see on here, or any errors that you see on these individuals. I did a roadmap, divorce and custody. This is primarily for the mentees to just get an idea of sort of a road of how to get to point A to point Z. Okay, these are, or beyond that even. These are just for your guidance if you need. Somebody recommended to have these last year, and so I thought not a bad idea. And also in your packet, you'll see some general fact sheets. Read them at your leisure. Fact sheets about family law that might help you understand it a little better. They're in the back on the left side. And then there's finally in here your family law cohort flyer that tells you the dates of upcoming events. The next program, which is on February 10th, will be remote. You'll all get a link for that. The final one in May will certainly be an in-person one because we're going to be giving out certificates of graduation. Okay. And I think that is, unless anyone has any questions.
That was yours, Nancy.
Please let us know. The format today is going to be a little different. We're all adults. If you have to use a bathroom or step up or stretch, feel free. Key to the bathroom is somewhere. I think I put it over there. Did they take
Oh,
it
that
back?
was men's,
Yeah,
but they're right here on the,
on the ledge.
yep, right on the ledge.
And
You'll
we'll
see them.
link to
Let me show
it.
you what they look like.
And so just get up as you need. And we're gonna make this more of a roundtable this year. Instead of Jessica just lecturing, we're gonna include you all. And we want you to jump in, whatever it is. Yeah. If you have an idea about something, Jessica says, if it's a question,
Yeah.
put your hand up and say, I don't get it, or would you explain that more? We just want this to be a real easygoing sort of roundtable kind of casual event today.
I don't want to talk for 3 hours. That's no fun to listen to myself for 3 hours.
And by the way, last but not least, as you all know, I'm Nancy Grimm, the Family Law Director, who as of this end of this week will be retiring as my position.
Oh, wow.
So, and it's very sad.
It is
For me
very
too.
sad.
For me, I'm just sort
No,
of,
I got the,
I can't even say it hardly. Jennifer Haber is taking my spot. She's not walking in my shoes. We're walking beside each other.
that's right.
She is, I'm always going to be in the background. I'm going to remain on the listserv. If Jennifer needs anything, she can reach out to me. She can reach out to you all on the listserv. She's great.
Oh, thank you.
And you're lucky to have her. And I think you're all going to really get along. And I want to tell you, Jennifer, when I sent out an email to the listserv, they said to me, we will help her as
Oh,
much
that's
as we
very
can.
nice. Thank you.
So we're not grumpies.
We're not throwing you to the wolves.
We're not.
Yes.
So we will help.
That's wonderful.
All right.
And I just want to say that I'm available too, so no one should ever hesitate to reach out to me for any reason. I want to be here for you 100%, and I'm so grateful to all of you. I really recognize, and I'm sure I will more and more, but I'm so grateful for all of you and what you do and recognize your incredible importance. So never hesitate to reach out to me, please.
Okay, and one last thing. Today is my birthday. Today. Oh, everything's happening 1 week.
Oh, my goodness.
Yeah.
You are not making it
there,
I got a
Wow.
birthday. Yep, yep. All right, Jessica, take it over.
All right.
Oh, and this is Jessica Zadjura. She is our speaker throughout the whole program, and she is a very active member of the Judicare panel and very knowledgeable of what she's about to tell you. So,
All right. I'll tell you a little bit more about myself. My name is Jessica Zadjura. I'm a family law attorney. I have been practicing in family law for, next year will be my 15th year. So I've been doing this a very long time. I have only ever practiced family law. I kind of stumbled into it. Turns out I'm halfway decent at it, I think. I have worked for other attorneys throughout my career. I went off on my own a little less than 3 years ago. So I'm a solo practitioner now out of Annapolis. But I have in my practice practiced in most of the jurisdictions in the state. My office was originally in Howard County. Up until 3 years ago, it was here in Baltimore City within walking distance of this building. And again, now it's in Anne Arundel County and Howard County primarily. I bring a lot to this table, but so do the other mentors. So please make sure you use your resources for the mentees and mentors while we're sitting here today. Please chime in. I won't tell you that I know everything. So I'm happy to hear from other people and other people's perspectives and experiences throughout the state. That would be very helpful to everyone here. Last year, Thomas Molinazzi, a colleague of mine, taught this cohort, and I learned a lot from him, and I've known him my entire career. So I hope to learn from you guys as much as you learned from me. Do we want to go around the room and just introduce
Yes,
everybody
let's do
briefly?
that.
Is that okay?
Yeah,
Great.
do
I
that.
know I'm taking more of our teaching time. I apologize, but
Just
I-
at 9:30.
Yep. So do you mind if I start with you? I know you
Sure.
just walked in the door. I'm sorry.
I can start, Lucilia Justiniano. I've been practicing primarily immigration law, and I've dabbled a little bit in family law when it comes to special immigrant juvenile status. So I'm comfortable doing non-contested custody hearings, but I am also a solo practitioner. I practice, my law firm is in Frederick, immigration law. I now
Oh, this was
practice
quite a drive for
nationwide.
you. I'm sorry.
Yes. I gave myself an hour and a half. Apparently that wasn't enough. But yeah, I'm excited to be here and see how much more I can help the Hispanic community, because I am also a Spanish speaker.
Nice.
Good, good to know.
Excellent.
And we need people in Frederick. We don't have as many attorneys there on the panel.
Okay.
So,
Frederick County Bar Association has a pretty robust family law section, which I'm gonna delve into, and hopefully I can pull some people.
oh, good. And
Towards this
send some
program.
people over
Yeah.
to us. Yeah, that'd be great. Thank you. Thanks a lot.
Thank you.
All right, Allison, you're up.
Good morning, everybody. My name is Allison McFadden. I'm one of the mentors. I did the program last year as a mentor, and I'm excited to do it again. My background is in family law. I've always, since the beginning of my practice, starting in law school, I did the family law clinic and just stuck with it. So I litigated at a mid-sized firm for about 10 years before deciding that I wanted to focus solely on helping people reach agreements outside of court. So I started my own practice where I don't litigate at all, but I do consulting attorney work with folks who are trying to reach agreements outside of court, as well as doing mediation and coaching. So I'm based out of Howard County. I wouldn't say I practiced all around the state. I practiced when I was litigating primarily in Montgomery County, Prince George's County, and a little bit of Howard County as well.
You chose no stress.
Lower stress. I wouldn't say no stress, but lower stress. Lower stress for sure. Yes.
Gracious.
All
I
right,
admire you.
so my name is Richard Lebowitz. I've been practicing now this is my 33rd year, practicing mostly family law now. I've done different, civil litigation, property law. I used to do a lot of landlord-tenant law, but now I focus primarily on divorce, custody, and other family law matters. I started off my career in Pittsburgh. I'm licensed in Pennsylvania and here in Maryland. And so I was 12 years in Pittsburgh, and then took the out-of-state bar in 2005. I've been in Maryland ever since. And I've worked with different firms in Maryland, but went out on my own in 2015 and been, solo ever since. And for me, I constantly litigating, divorce and family law matters, primarily in Baltimore County, Baltimore City, Hartford County, Cecil County, Howard County, Carroll County. I try, and Arundel, I try to avoid Prince George's, but I do have some cases from time to time. It's
That
just
makes
more of
all of us
a,
rich.
it's more of a distance issue. I'm at the point now where, I don't need to drive 2 hours each way to get to a hearing. When there's probably somebody local there, I can refer the person to, let alone do they want to pay me to sit in traffic for 4 hours while I get to their hearing. Because I always joke with people the last time I was in Montgomery County, I got there, parked in the open air parking lot, and went into the courthouse, which, as we all know, that was all torn down, by the movie theater. It's now a big, complex with an underground garage.
That was a long time ago, Rich.
Well, it's been a few years. I remember, I have memories of going to the historic district court, and I know they built a new one across the street in Rockville, but yeah, I've even going to that landlord-tenant commission in Montgomery County. But no, it's just been a while since I go there, but I do go to all the surrounding counties, and and I've been a mentor over the years through other volunteer services, and I look forward to working with MVLS this year.
The moral of Rich's story is he's very seasoned.
I guess that's one way of putting it.
Yeah.
He's been around a while.
Yes.
Excellent.
Excuse me, my name is Michelle Mansulich and I'm a mentor and my mentee is right next to me. So I'm excited to be here today to meet her. I would have to say that I've tried the large law firm thing and realized that that didn't give me the autonomy that I needed or the autonomy that I wanted. And so I'm a sole practitioner as well. Family law is my advocacy and not my avocation. I decided long ago in my life that I would, if I had to pick something that I would dedicate myself to, it would be family law. So I am very happy to say that I have met this wonderful organization, MVLS, who has given me this great opportunity to do exactly what I like to do. And that is forward my advocacy for the benefit of the people of low means. And they actually do not have a voice in the justice system without us. And we make a difference in everybody's lives. And that is what is so astonishing about this organization of MVLS, that it finds so many people like us. I will say that you will not, and the reason that I like MVLS as opposed to having been in a large law firm is the autonomy that I have. I can get on the listserv anytime I like, and somebody will tell me where I can go to do something, or they will put me in the right direction, or they give me a million different ideas. And that is what has been my draw. I started in Baltimore City, and I've been around for a long time. It's like Rich. I started, I was barred in 1998, and the very first job that I had was in this building at Cooper and Turk. So I find it fascinating than coming here again today. I haven't been in this building for a while. I'm a hybrid. I do have other ways that, if I want to support myself, I am able to support myself through some of my other areas that I practice, which is states and trusts. I love drafting deeds. I'll do some debt collection. But what I find is that those other areas of law just only help me as a family law attorney, because I have so many other options that I can offer to my clients. As far as litigation goes, I had the most wonderful experience in my life. And I was a contract attorney for ExxonMobil for 23 years. And I had a 23-year career case in litigation. And I worked on the ExxonMobil merger. I've seen thousands and thousands and thousands of boxes of documents. I've read thousands and thousands of documents through the AI tools and produced many, many documents. So I've had the opportunity to travel the world. I've had an office on K Street in Washington, D.C. I worked with Ted Wells, who is probably one of the most famous attorneys, and absolutely positively a U.S. Supreme Court practice. So I consider myself a brat, but because family law is my advocacy, that is why I'm here today.
And one thing, Michelle, she does her work primarily out of Cecil County, and we have no attorneys in Cecil County. So I can always count on Michelle to take one of those cases.
So nice.
Thank you. Cecil County is probably the prettiest drive that you are ever going to take. And so if you don't mind having a day where you can just sit in your car and just relax, even though it's crazy on 95, take the express, you can be there in about an hour and 20 minutes. The courthouse is very lovely. It is a challenge there when you go to a jurisdiction where, and I don't mean, this is not a negative, this is a challenge for you as an attorney. When your law firm, not me, but the law firm that is there is the only game in town, You have to understand how the dynamics of that within the court system. And you've got to do a lot of deep down soul searching to understand how it is that they operate. And I just want to say one thing that I think is really critical for everybody who is an attorney. We are never always going to be told the truth.
That's the understatement of the century. Yes.
By who? By the man, by the.
Any of them, any of them.
Yes, we are never, ever going to be told the truth. And so what you have to understand, what I have come to understand is that, and I don't even know how to put it, it's just something that's become very apparent to me, is that the cover-up is not only by the client, but it's also by the attorney. And in order to, and this is the best way I can put it, in order to avoid being the person at fault, they turn the table on the client or possibly on the attorney. And so you have to learn how to watch your back, and you have to learn the dynamics of how it turns out that even though your client really might be 100% innocent, how they can turn the table on your client. And you've got to learn how to overcome that. And that's the most important thing that I've learned in the practice of law. And where do you go and how do you stand your ground and how do you defend your client? Not only defend your client, but yourself.
Thank you, Michelle. That's great.
Yeah, I compare notes with you for CISA. I was just here last week. But yeah, yeah, Magistrate Reeds loves me, at least knows me. I always says hello to me whenever I walk in the courthouse. Sure.
Good morning, everyone. My name is Yvonne Clue. I'm really excited to be here because I have 0 family law experience. So grateful for everybody that's a part of this.
Sometimes that's the best kind, I'll be really honest. Coming in blind and, yep, clean slate, no bad habits.
So thank you for putting this program together for everybody who's contributing their knowledge. I really appreciate it. I've done disability rights work in New York. I've worked for Social Security. I now work for the VA. I'm also a small business owner, so I've done like some business. I've dabbled in business IP, but family law really came kind of to the forefront a few years ago. My family's from Ghana, West Africa, and I decided I wanted to go there, spend a couple of years and get my license to practice there as well. Wow. So while I was there, I finally took a family law course and it was really, really interesting. I found it very fascinating. So I said, I want to add this to my future firm that I plan to open for myself in the future. So that's why I'm here and I'm excited to be here.
Awesome.
Thank you.
Awesome.
Hello, sorry if I'm talking a little pain. I'm like Humpty Dumpty. I had a great fall this weekend.
Oh, no.
I'll be okay, but I'm just a little sore. But, my name is Edith Serrano and I spent an hour trying to get around the corner. And, primarily I do domestic violence work for the YWCA in Annapolis and Oranto County. But I do have my own practice where I do education law and family law.
Do you do like IEP litigation and
I'm
those,
sorry?
like IEP 504 type stuff?
I started there, but I'm more with the college and graduate students
Okay.
and academic dismissals and things like that.
Okay, that's good to know. Thank you.
Great.
All right. My name is Carrie Campbell Garrett, and I'm so glad to see my mentee came in. I was looking for her. So I've been in practice, it'll be 20 years in December. I've always been in private practice. I kind of started out under another attorney and, he just kind of just threw me out there. So I've kind of just learned like trial by fire
Yep.
so many times. But I really never really wanted to practice family law. I was always criminal. Let me fight for, the little people because, And then somehow I fell into it and I keep falling into it. And so I just stayed in it because I found that I've actually been very good for people in family law just going off of what, my clients tend to say, like you operate with compassion, but yet you're a pit bull. So I think I found a good mix to try to be helpful to people, but kind of like when Nancy was asking for a quote, like I appreciate what we do in terms of how we affect the lives of people today, tomorrow, and years later. So just having an appreciation for that makes me do my job much better because I don't take anything for granted, which again lends to a lot of stress that I'm talking about, just because it's not enough to work, with that time that you're in the office, but I'm working on Saturday because my mind is going, I'm working on Sunday because my mind is going, because you're always constantly trying to think of how can I help this person? What can I do? And sometimes, I'm a little anal. So I'm like, Carrie, you read that law, like that case 10 times, like, all right, well, read it 10 more to make sure,
It'll hit different than.
but that's the kind of thing that family law will make you do because you just want to help people. And I do sometimes say, give me a criminal because it's less stress. It's like, whatever, they are emotional, right? They don't come with emotion. You're like, what I did or didn't do it, whatever. But it can be very rewarding when you really do what's in the best interest of the kids and you get the result that you truly believe. Now, whether you're right or wrong, but if you believe that you are, then you kind of get that, sense. So, also one of the people who would love to reform the way we do to make it less adversarial and more of a almost like collaborative, or trying to figure out how do we make it so much about not counting days, and things like that, which if you haven't done family law, there's, we talk about child support, a certain amount of days that you want to get so that the child support is this and not that. So, and that's what, so a lot of times our system becomes is about the days or how much can I get because I'm upset, so that's right. So there's a lot to it. So,
Buckle your seatbelts.
Yeah.
Family law is jack of all trades,
Yeah.
master.
I mean, everybody's making it sound so wonderful, like, I need to go work with them. No, but.
I mean, we have to sell it to these.
I don't want to be jaded yet.
Yeah.
We were supposed to just introduce ourselves, not say why we hate what we do.
I love it. No, but that's the reality.
You're not
No,
wrong.
I'm talking about
There is no off in family law. You are not
the
wrong.
practice in general, not me.
Mhm.
Like, I love it when I come across, because I've had cases with Rich before, and I'm like, listen, what can we do to try to see what we can do to help these people?
Yeah.
Right?
Those are
That's
my
my
favorite family law.
approach, right? But some attorneys don't take that approach.
They're becoming fewer and farther between
They
the
are.
longer I practice.
Yeah. And so
Very
that's why I want to say, as a practice, you kind of want to get back to what can we do to help these people? Because when we start having problems or we start being about something else, then we do a disservice to our clients.
That's right.
So you just want to come in with the mindset, what can we do to help?
Yeah.
Not what can I do to make it worse?
Yeah, we're more of a team than
Problem
people
solver.
realize across the table.
Yeah,
So-
that's right.
So, no.
Reunifying families rather than,
Mhm.
this sort of
Divisive,
adversarial
yeah.
divide,
Mhm.
All right, Curtis, all you.
All right. My name is Curtis Cooper. I've been a lawyer for, I guess, 24 years. Started out in West Virginia, but moved to Baltimore, where I'm from, after a couple of years. I have a daughter who was born with disabilities around that time, and that's part of why we moved back to Baltimore for her care. But I've done a fair amount of disability law over my career. I went out in solo practice, and I think this is a theme I've heard from many of the mentors, which I think is cool, but it gives a lot of flexibility. It lets you take cases that you choose and care about. So I miss, I think, being in a big firm, maybe you get here's the way you do it, and it's got to be up to a standard. And when it's just you, it's all on you to not only do the practice, but do everything else with running the office. I actually didn't do family law for the first half of my career. And there was a younger attorney who was in law school who I was kind of mentoring, and he just started doing family law cases. I mean, there's such a big need for it. So I came to MVLS and did a training before there was this kind of mentorship program. But the deal was you'd take a case if you did the training. I sort of enjoyed it, and it's been a increasing part of my practice since then. There's a lot of great things that MVLS offers. Just like these events. There's the listserv. I think I'm on, there's a big family law listserv called the Goldberg listserv. That it's sort of like freewheeling and people post anything, but the MVLS listserv, I think the quality of the responses you get on it are just as
I agree
good.
with you.
Yeah.
Sometimes they're better, candidly. There's a lot less discourse and a lot more education in the MVLS family law
That one
listserv.
too, so yeah, I agree.
Yeah. I'm looking forward to celebrate pro bono on October 30th, when I think Michelle is going to be honored as law firm of the year. Another thing, so Nancy put together a program on mental health for a pro bono resource center conference that happens every May, and it was a great program. I think there was like one of the panel, Judicare panel attorneys was one of the presenters. But she and I are planning one for February for the Baltimore City Bar Association. It'll be virtual, and so we'll share that
Yes,
information
please
out.
do.
I'll let you all
Thank you.
know. By the way, I have a little tidbit to tell you, a little secret about Curtis. He speaks fluent Russian.
Oh, wow. Good to know.
In case you have a Russian client,
That's good.
he's your man.
All right, Bocce, your turn, my dear.
Okay, I think I'm the only student here. I'm a foreign trained, and I love that. I'm a foreign trained attorney. I'm from Ethiopia. And I do speak Amharic if you have any clients. Trying to compete with, okay. So I do have a lot of experience in project management, business development, training, and but I'm like moving here about a decade ago. And ever since, of course, my initial graduation, I always wanted to help the community. I'm a very family-oriented person, but after moving here, I was so committed to do immigration law because I've seen a lot of issues, and I'm also part of that community. Then I took a course with Professor Lawrence, I think good friends with Jessica, and it just enlightened me in a way, like there are no Ethiopian family law attorneys near here in Baltimore County, in Baltimore City. And I feel like I can connect really well with the community, and I can assist in that route. And family is a big part of Ethiopian community. And I've seen a lot of kids lose their parents, a lot of divorces are happening. Kids are losing their parents in so many ways. I think we can do a lot to just protect that. And I just want to come in and serve. I have basically no experience. Recently, I joined this amazing law firm as a law clerk. I feel like I'm in an ocean swimming, and you know what? I can swim. I don't know how to swim, but I'm really doing it. Imagine me. But I'm learning every day, and I'm so glad to get a chance to meet you all. And hopefully we will, of course, my plan is to open my own law firm in the long run. Once I gained, and once I'm sure that I have all the experience that I needed. I'm so glad to connect with all of you and Curtis. I'm sure I'm like ready to learn and observe as much as possible. I'm not barred yet, so bear with me, but I'm sure that I'll serve with you all in the future and now. And yeah, thank you so much for having me.
Good morning. My name's Sarah Furlow. Sorry for my tardiness. I feel like the instructions should have been like make time. So we sit on Charles Street.
Well, there was more traffic than normal on Charles Street, so we did delay.
Fire engines shut it down.
Yeah, that was like right after I got here, so.
It's been a while.
On the listserv, we all need to write a note about be leery of Baltimore City traffic and give some good hints on maybe how to avoid the downtown, which is, I did that.
Yeah.
I know it gets crazy.
Yeah, well, it's been a while. I started off my legal career at Maryland Legal Aid. And so I would come to downtown, I don't know, like quarterly or something. So I know it's bad. I just didn't expect Charles Street to be like standstill. But I started off doing center work, representing children in foster care. And then I took a detour to labor and employment, which I really, really loved and miss a lot. But I think I'll take a little bit time to like circle back to that because I was representing primarily federal government employees.
Oh my.
And since
Yeah.
that's like a disaster right now, I'd rather not be frustrated with not getting much done. At the moment, I've been at Delaney Stafford for about 2 years. They are a boutique family law firm, but they serve clients who are like high net worth clients. So a lot of their cases are very like financial. In May, I kind of switched roles at the firm. And so I am now of counsel and I've been building out a BIA practice, but also going out in the community.
What's a BIA?
Best interest attorney.
Yeah. We'll talk
So,
about that a little bit.
so I've been building out a best interest attorney practice and casted a wide net. And the folks in St. Mary's County reach out to me often.
They
So
love
I've
you
been
down
doing-
there.
I've been
That's
doing-
quite the drive.
I've been doing a lot of 2-hour driving, one way to go to court, but it's really pretty. And
Oh, St. Mary's County is
it
beautiful.
looks like right now for Halloween, it looks like something out of a Hallmark channel, like it's all decorated.
Yeah.
So I do look forward to seeing what it looks like in the holidays.
You're so positive about that commute.
I mean, well, I'm gonna be there for a while. I'm also working on a pilot program in Charles County where they are appointing child advocates and
I do a lot
custody
of work
cases.
in Charles County, so I'm happy to help you if you need help.
Okay. Yeah.
She's like, I'll take you up on that.
So I enjoy representing children. I love working with children, but also just looking for an opportunity to work a little bit more with adults to make sure I don't completely hate it. I'm just newer to family law. Like I'm not new to being an attorney, but just as someone who is always like signing up for trainings and things, I'm always looking for opportunities to like learn a little bit more. And so when I saw the email, I thought this would be a fantastic opportunity. So here I am.
Great.
Awesome.
And Erica, last but not, did we want to introduce you? I'm sorry, I just kind of skipped over you. You're a staff member here, aren't you?
Yeah,
Okay.
so my name is Maura. I'm a senior paralegal here. You've probably seen my name in your inbox.
Yeah.
multiple times. I've been with MVLS for about 3 years and it's been great to work with Nancy and the listserv. And in the future, I'm interested in pursuing social work. So working with Nancy and the Judicare panel has been very educational. So it's good to see all your faces in person.
Thank you for joining us.
And I just, before you start, I swear, I want.
I was gonna let Erica introduce herself. real
Oh,
quick.
Erica,
Sorry.
I know, belated Erica, which ironically, Sarah was late and I was too, and we are mentor mentees, so it's our beautiful relationship. Yeah.
That sounds lovely. You can drive to St. Mary's.
Yeah,
County
no,
with her?
no.
Absolutely not.
There is, a limit to how much I love MVLS. St. Mary's County might not get there till dinner time, but good morning, everyone. I am Erica. I didn't hit any traffic because I was so late. There was no traffic. So I'm so sorry, but it was really quick to get here. I'm approaching my 30th year in December in family law. I represented every general litigant for about 15 of those years. And about 15 years ago or so, I started winding my practice down, which is why Sarah is also going to be terrific. And I focused just on being a BIA. best interest attorney. So I did that. I've done that for about 15 years, and I'm also a parent coordinator, which is sort of where my love is right now, because it's, I don't know, does everyone here know what a parent coordinator is? It's like, so I will explain, it's under Maryland Rule 9-205.5. It is like the best way to describe it, it's like a mediator with decision-making authority.
Yeah.
So I help parents learn how to communicate with each other. I work on providing education, a safe space to talk, to work through issues. And if they can't work out an issue, I then make the decision if they've given me that authority. It's just on minor issues. It's not an improper delegation of judicial authority. I can't be like, oh, I like Curtis, I'm going to give you custody. It's, you all can't agree what time to pick up on Friday, so I'll make the decision for you. And it's the most minutia you could ever imagine. But again, being child focused, happy parents, happy child doesn't really rhyme very well, but so that is me. And I'm excited to work with you and share knowledge. And I didn't have a mentor, and that's why I love doing this. I worked with my dad, who is a criminal defense attorney and one of the best, but didn't want to touch family law with a 10-foot pole. And no one in our office did either. So I sort of muddled my way. And in tribute to Sally Gold, who was my sort of de facto
Sally.
mentor, who
Sally
recently passed away, who was the most amazing mentor to so many people. So this is my way of sort of honoring her, giving back.
That's so nice.
The most amazing mentor with the most amazing outfits.
Yes, exactly. Hats and scarves.
Very good.
Erica Danneman. I mean, I'm now Erica Slater. I was Erica Danneman.
Okay, I'm just keeping in mind for a parent coordinator, because
I do community work too. Just so
I
you
just
know.
want to say,
If you need somebody ever.
that is not minutia.
I know.
It is the most explosive thing in any relationship between co-parents. And they fight more than anybody I know over exactly what you said.
well, you spent 3 hours talking about where the child goes for Christmas Eve and Christmas, like 3 hours.
I want to flip coins for property.
So to have it,
Recreational sports are a really big one.
Okay.
to have it,
I'll talk about it.
Yeah, and Jessica's going to start. I just want to let you know that everybody here who is a mentee will be put on the listserv. When you get on the listserv, it's an opportunity for you to just see what's going on, how we communicate, what we talk about. You cannot take a case, because I post cases on there that are for experienced attorneys, but it certainly gives you the education that will help you to see how things are done. Okay? All right. Now, off to Jessica.
Thanks.
Hit
One
it.
last thing, Nancy did say she's gonna circulate everybody's contact information.
Yes.
So feel free, I will offer up my services to the mentees. If you have questions outside of what, your case with your mentor, or just about the practice of law, or anything you need, please feel free to reach out to me. I did think it was interesting that all of the mentors are solos.
Yeah, and the majority of those on our panel are solos.
Or very small firms, not your larger
Yeah.
firms. So I'm just interesting that everybody sitting in this room is a solo.
Yeah.
So.
I don't think that to be honest, I don't think some of the larger law firms or the other firms would really appreciate if you said, hey, I'm a pro bono attorney. I just
Yes.
think they would appreciate that.
All right, so let's get started. I'm gonna talk fast because we spent a lot of time doing introductions. So one of the biggest things about family law, and certainly mentors chime in, is that you spend a lot of your day managing client expectations and boundaries. I know in my own personal experience, it's taken me many years to set boundaries with my clients. I don't respond to text messages personally. I think they're very hard to track. They get lost in the shuffle. There's no way to really record keep them in a client's file from a communication perspective. You also have to set boundaries about, your own mental health and your own work-life balance. Obviously there are times where you were talking about this, you have to work on the weekends, you have a trial or, last minute settlement or a true emergency, but you as the attorney get to decide what is a true emergency. For our family law clients, everything is an emergency. And I understand and empathize and respect that, but because they are living it, but their emergency is not always my emergency. So that is certainly a boundary thing that comes with age and experience. I think when I was a much younger attorney, it was a lot harder to set those boundaries than it is now. As I'm sure you're all aware, there is difference between empathy versus sympathy. As sympathy, we can be empathetic for our clients, but we don't have to sympathize with them. I have found in my many years of practice that it is better to under-promise what the outcome of a case is, or when you can provide, a response, a document, something for them to review, whatever the case is. What's the saying? Under promise and over deliver, right? That goes back to the client expectation and client management. The other thing that is very hard for many family law attorneys, in my experience, is this is not your case. You don't need to align yourself with the client's position. You can advocate for them, but I think once you adopt their position and you struggle with not seeing where they're not telling you the truth, not seeing the holes in their case, those sorts of things, that's where you get yourself into trouble in negotiations, before magistrates and judges of this state. So your job is to see things from all sides. Think about what the argument is from opposing counsel or the opposing party's perspective. How can you defend that? How can you better your client's position in a particular case? I always tell my clients, if I don't know the skeletons in your closet, I can't help you. And if I'm finding out whatever that skeleton is while we're sitting at trial table, I can't get out in front of it, right? Sometimes getting out in front of whatever the issue is really kind of the best method. Did your client smoke pot? Did your client get a DWI? Did your client, have a mental health breakdown? Whatever the case may be, sometimes it's better to just get out in front of it, because in the court's perspective, it really takes the sting out of whatever the issue is. And how are you remedying whatever it is? Are they in AA? Are they going to therapy? Are they under getting medication management, or whatever the case may be, right? So certainly making sure that you are not aligning yourself, setting realistic expectations, those are all very important.
I always tell my clients, don't make me the dumbest one in the courtroom.
That's a good way to say it.
Don't make me the dumbest.
With family law clients, blunt is better, in my experience. Do not leave room for misinterpretation. If you do not understand the words that came out of my mouth as a client, then we have problems, right? That's where they get themselves in trouble. They start making decisions that are not helpful to their cases. Like I have learned, and my husband kind of hates it, but I am pretty straightforward. And if you don't understand what I've said, we have problems. All right, what tools do you need? You need the MVLS Family Law Listserv. That's what you need. There is, many of us, not me, but many of us have a lot of experience in other different backgrounds. Curtis, I have to say to you, one of my favorite people to chime into the listserv is you, because you have such a different perspective oftentimes, because you haven't always practiced family law, right? And so you look at the world in a very, very different way. We all bring different things to the table. Please use your resources. The thing about family law is you need to know attorneys and experts in every field you can possibly imagine. We are the, jack of all trades and master of none. And the best family law attorneys, in my experience, use their resources, whether that's a treatise, the rules, the family law article, the real property article, whatever the case may be. We need to know all sorts of things. You need to understand HIPAA. You need to understand, what happens to retirement assets. You need to understand, the financial implications of, what happens in a property settlement, all of those sorts of things. We all know that there's plenty of mental health. You need lots of therapists in your repertoire, in your Rolodex, whatever you want to call it. All of those people are oftentimes your best resource, and sometimes they can cut to the chase and give you a different perspective on what's going on in your case. The internet, I think the network is the most important of the ones up here. Obviously a horn book, there's a very good, what's the blue horn book, Nancy?
Vaders.
Yeah, thank you. Vaders, that's a really great one to have. Yeah, Vaders. I don't think they've come out with a new one recently, so there's probably a lot of.
There's I think John Conliffe is one of the co-authors of a pretty recent one, and he's on the MVLS Judicators.
Yeah, yes, he is.
And that one's Maryland Divorce and Separation Law.
Yes, correct. My favorite handout in this little packet are the legislative updates.
Yeah.
The fact that Nancy and Jennifer gave us all the last several years worth is very helpful because in the early years of my career, there were not a lot of legislative changes. And in the last probably 3 years, I mean, some of these years, there were 2 pages worth of legislative updates. You are seeing our world change very drastically, and we're going to talk about that some this morning. I think that's really kind
And I
of.
want to say to you one thing, is that when the listserv was first developed, the purpose of it was the fact, I was a volunteer attorney way back and continued to do it until I took this position. And I didn't know who to turn to. I didn't know who was out there that did what I did, thought like I thought, and could give me some advice. So I thought, let's do a listserv and see, if you build it, they will come. And they came. And you
They
all
never
came.
leave.
And they never leave. So it's been a wonderful addition, I think, to allow these people to know we're all out there and none of us know everything.
It's called the practice of law for a reason.
Yeah.
That's what I always say, right? Like, I mean, in law school, your professors would lead you to believe that there are dumb questions, but I am a
There are
believer that
never
there are
dumb
never any
questions.
dumb questions.
I think the diversity of ideas that you get back is also really helpful.
Yeah.
Sort of challenging, like you think something, but 4 other people might have a different view. I think that's really helpful.
Yeah, I agree with you wholeheartedly. That's why I think that listserv is one of the most beneficial things. Go ahead, Elsa.
I just want to share one other resource, the People's Law Library, which I think is through the judiciary.
Yes, they did a great job updating that during COVID.
Yeah, and they give really, like, I would say, basic explanations of like common family law things. So I found it really helpful to also send it to clients.
Yes.
So that they can review it. Sometimes they might not like what you're telling them, that this is how the law applies, but like seeing it in black and white can be helpful, that like you're not just making this up, right? Like this is what the law says. So I found that to be a really, really helpful resource.
And they update it very frequently.
Yeah, and there's some videos on it too.
Correct.
And case law.
Yeah, there is case law and it links to all the statutes and the rules and all of those sorts of things. I will tell you again, family law touches so many different areas that sometimes when I don't know something, I actually start there. It's a great place it's a great resource because it's accurate, right? And so obviously I end up down a rabbit hole when I'm doing research, but it's always a good place to start.
Absolutely.
That's much more reliable than obviously Google or ChatGPT. So. All right, issue spotting. So one of the big things is spotting all of the issues in your case very early on, because if you file a complaint and you don't ask for something, you're not entitled to it. We deal with divorces. Some of them have custody, some of them do not have custody at issue. Sometimes you're dealing with unmarried parties and you're dealing with the custody issues that come with that. Child support usually goes hand in hand with custody unless there is a filing through the Office of Child Support Enforcement, which is really just another mechanism for them to deal with that. My typo didn't come out of alimony. I'm sorry.
Oh,
Jennifer.
no,
It's
I'm
okay.
sorry. That's
all
my
right.
doing.
Sometimes there are alimony complaints, standalone. Usually they are involved in divorce. I will tell you in all of my years of practice, and everybody speak up, I don't think I've ever filed a complaint for alimony separate from a complaint for divorce, but you can in fact do it. I just don't think it's something that happens very often. Property division is also incredibly important. We don't see so much of that really in MVLS judicare cases because that would disqualify them for our services. But when going out into the big world of family law, property division is a big one. Modifications, those are going to cover just custody and child support. Those are the only 2 modifiable things with the exception of alimony in some limited circumstances. Again, probably not something you're dealing with in MVLS cases. Sometimes there's emergencies, domestic violence, or contempt or enforcement issues. Thank you. Yep, half of family law is managing clients, and the other half is pretending you didn't hear them tell you that they did something stupid. Yep. How to get the results you want. I was gonna say, is there a way to move things? Yes. There we go. That's perfect. So you have really 3 options. The parties can come to an agreement, which is your first option. The court can enter an order over one or both parties' objections, or some party can take unilateral action. That's not often the case, thankfully. self-help is pretty frowned upon in family law cases, especially when it comes to property issues and custody. You have several dispute resolution options. The parties can negotiate amongst themselves with or without the help of counsel. The parties can negotiate with the assistance of a mediator. Does everybody know what a mediator is? Okay, so a mediator, I see all my mentors shaking their heads, so I'll give a quick lesson. A mediator is a third-party neutral who will assist the parties in hopefully reaching a resolution amongst themselves. They don't necessarily have to, but it's often the basis for a starting point. I don't know about the rest of the mentors here, but I am a mediator for many of the jurisdictions. The court will order mediation in most custody cases with limited exception, usually only in domestic violence instances, although in my practice, I'm finding that they are ordering mediation even in instances of DV via Zoom, because there is a way to protect parties in your, not that DV is ever not severe, but your less severe DV cases, for lack of a better way. Go ahead.
Just curious what it takes to become a mediator. It's like a training you go through and then.
Yes, so there is a 40-hour basic mediation course. MSBA puts it on. They actually just put it on, I think at the end of the summer, if I remember correctly. You can also find ones online that meet the Maryland qualifications for that 40-hour. That is mediation across all practice areas. And then in order to be on the family law panel for the courts around the state, you have to take 2 additional classes, depending on what subject matter you want to deal with. If you only want to deal with custody mediation, there's an additional 20-hour mediation course that is specifically tailored to custody. CC Pays, P-A-I-Z-S, has been around for years and years and years and years and years. She does the mediation training through MSBA. It is, again, 20 hours. It was all virtual. It was actually just last week. She does it once a year, usually in the fall. Cece trained me, so you'll hear me sing her praises until the cows come home.
Can I chime in too?
Sure.
There's also the community mediation centers of Maryland, and you can train through them for free.
Do they do the training?
Yeah.
I have not had, I've had trouble finding it recently.
You have to connect with your local mediation center.
Okay.
And then you have to apply, and then they will link you into the training. But
Okay.
it's 3 full days of training, but you also have to make a volunteer commitment. I've actually done both the bar training for mediation and the community mediation centers. It's 2 different kinds of mediation, but the bar one costs money and is wonderful. The community mediation is also wonderful, and you can do it for free, but it does require a volunteer commitment. Having said that, the community mediation centers are awesome. So
Yes, and a lot of the counties use the community mediation centers
Yes.
for their court order
Exactly.
mediation.
To get on the
One in
court
Cecil
roster.
County. And I was in court yesterday and the judge offered the community mediation center, which is free to both parties.
Yeah.
And when you're in pro bono, anybody that has that is great. So it may be worth the effort to do that.
Yes, and the
Yeah.
community mediation centers will mediate anything. Now, their mediators generally are not attorneys, but they will mediate anything for anyone. There's no requirement for your finances. So it's a great resource, especially for clients that are low income.
And
or
then
no
just to
income.
finish my answer, and Allison, I'll come to what you were going to say in just a second. I did hear you. There's a 3rd class 20-hour property if you want to do property mediation. I think the community mediation center will, I assume, train on that one
They
too.
do parenting, I'm not sure about property, but I bet
Okay.
you're
The
right,
Howard
but I
County
haven't
one
seen
does
that.
it.
They do.
Yeah.
Oh, great.
Cece does the training
Great.
too. It's coming up in December, I think.
Property.
I trained with Cece many years ago before she started doing it for the MSBA. So I've known her for a
Oh,
very long time. She used to do
great.
it privately in her office. Go ahead, Allison. What were you going to say?
I was just gonna say, to get on the court rosters, you also have to either have observed or done co-mediations, and it can be difficult for a lot of people to find
Mhm.
that opportunity. So the community mediation center can be a great way
Yes.
to get those first couple under your belt.
I'm also happy to let anybody observe as long as the parties or
Oh, that's,
I do it all the time.
that is a gift,
Yeah.
because it is hard for people to.
Yeah,
make their
and
hours.
I will tell you, if you do pay for Cece's class through MSBA, she is now offering any of the class recipients the ability to observe.
Wow.
Awesome.
So I observed her when I was practicing on my own, but I do know, I have a friend that's I just took her custody class, and I know she is offering that to any of the
Awesome.
trainees.
That's
So
great.
just to put that out there. Did that answer your question?
Yes.
Okay, that was a long answer, sorry. Collaborative law, is anybody here collaboratively trained? Okay, Erica, do you want to, or Rich, do you guys want to explain collaborative? I've never been trained in it, so I feel like I'm not the best person to explain it.
I've been trained in that. I've never actually done one.
Okay,
Only
well,
because
we can all be in
I
the
like,
same
I
boat
like to
together.
have the control. So essentially with collaborative law, it's where you're essentially, trying to, mediate a case, but instead of focusing on litigation, you're signing a fee agreement that allows you to, the same way like a mediation, that whatever says mediation is inadmissible in court. So the idea is that you're basically lowering the bar as to what you can communicate with both parties. So kind of like in that, circle up there, that as the attorney for, say, husband, I then have the right to still talk to the other parties and have direct contact with other professionals, whether it's a therapist or a financial advisor or other professionals, and basically have more access to information that I wouldn't otherwise have if I was litigating the case. So then if we can negotiate an agreement that way, great. If we can't reach an agreement, then I cannot continue to represent my client at trial. So essentially, I always look at it as I do collaborative light usually, where I would do a 4-way meeting with counsel or bring in a retired judge as a mediator, where I still retain the ability to go to court. But a collaborative law is for the right person who really just wants to negotiate a marital settlement agreement before trial, but without actually filing anything yet. And it really takes the right person to find, is willing to open-minded to try that. So essentially it would probably not work for any MVLS case because it's with somebody, it would have to have someone's higher end who really does basically understands the value, that doesn't want to go to court, but also has the resources to hire the other professionals. Because essentially it's like as a team, you would be working with the mental health professional, the financial advisor, maybe the divorce coach or other people in the room. And do all that together. I have yet to find the person who's willing to pay for all those other parties. But yes, that's my understanding, at least my understanding. Correct me if I'm wrong, Eric, because I'm sure you do that.
That's my understanding too.
Isn't there like a collaborative law center or something like in Maryland? Like, are there a couple of like firms that do only like collaborative work?
In my experience, they don't do solely collaborative. I've come across a lot of collaboratively trained attorneys in my experience. And I see Curtis chuckling over there. I've never seen any of them be completely.
I'm just thinking of one person. I've heard, from a couple people here today and other people, it's sort of like, I'm done with the fighting and I'm gonna like do mediation. I'm gonna do parent coordination. But I can think of one attorney. I don't know if she's still practicing, Stacey Anderson. It's very big.
Yeah, she's in Annapolis now with Nancy Weller.
Okay, so I don't know if she's just doing collaborative law still.
She's
that's where her heart.
Retired though.
Yeah.
Too. Yeah.
There's a woman in Montgomery County. I can't remember her name, but she's part.
Yeah, and I was just gonna add, like, one thing in these cases that is enormously time consuming and expensive if you have a paying client is discovery, right? So collaborative law is a good way to kind of keep from like, the attorneys can bill a ton and just like, and frankly, this happens a lot. I think some firms are like, no, we're not going to agree to mediate first. We want to get this discovery out. And there's really no good reason a lot of times for it, but it's a way to add to the bill, I think.
Yeah, I don't disagree with that. The thing I experience with collaborative law is because you often have attorneys, the parties, and other experts, a financial expert, a
Parenting coach.
a parenting coach, a custody expert, a mental health professional. It's also very time consuming because it could take months to get a second meeting on the calendar with all of these professionals in one place. I mean, sometimes just going to court and trying to schedule something with another attorney, you book 3 months out when the court had something 30 days from now because the calendars are so busy. So I think that's one of the downsides. I think when it works really well because the parties are motivated, right? But it's not going to be something we deal with here in MVLS because you're often dealing with your much more higher income earning, families.
Right.
Okay. But to answer your question, yes, there is a collaborative law center. I don't know of any attorney that practices exclusively in that area unless they're like approaching retirement or only really need to work part-time because they're, especially now with the economy and all of those sorts of things, you don't see a lot of families, in my experience, that really have that income level to be able to bring in everybody that's needed. And what you end up finding, in my experience, and you guys correct me if I'm wrong, is people ultimately say, okay, well, we're just going to mediate. Because really the alternative to it, right? So, after that, you really have settlement advocacy where the two attorneys are going to mediate between themselves on behalf of the parties. And then your last but not least, favorable option is obviously litigation and court-based. I would agree with what's been said here. That's really not an appropriate world for family law if we can help it. Sometimes you have no choice. Sometimes a case has to be seen all the way through because you have an unreasonable party on the other side or an unreasonable client. That is sometimes just an option. Unfortunately, what is very frequent in family law, in my experience, is that you will reach settlement in the days leading up to trial or even on the courthouse steps, the morning of trial. Yeah. Anybody have any questions about that?
I have a stupid question.
There's no stupid questions, ma'am.
Settlement advocacy, so does that just end in a settlement contract and that's it? There's no judge's order granting custody or?
Yeah, so what happens if you reach a settlement agreement resolving all issues in a case is you still have to, one party still has to file for divorce. It becomes an uncontested divorce. You have taken all of the power from the judge, other than essentially they're rubber stamping a judgment of divorce, because that's the only way to get a judgment of divorce. Or if you have unmarried parties and there's just a custody order for a custody agreement, for example, because sometimes there's a parenting plan. Often you want to enroll that parenting plan with the court because of if you ever need to enforce it if somebody stops following it. Does that answer your question?
And
There's
that was a very good question.
Yes, that was not a stupid question.
Yeah, I mean, I think normally parties are supposed to be like at least voir dire, which is like, they're testifying that they agreed to this voluntarily and things like that.
And it depends on the jurisdiction. So during the pandemic, it became more of a problem where you could negotiate an agreement. I could say draft a consent order for both parties to sign because it's a court settlement. But some courts would then require to schedule an actual hearing to voir dire the parties. Is this in fact your agreement and is it in the best interest of your child? And others, if you file that, especially with an attorney, the court would just sign off on it and not need a hearing at all. It just, there's no rhyme or reason where some judges sign off on it and some don't.
That's a really good point because it's one thing, you need to know where you're practicing. You need to know what are the sort of local rules of each jurisdiction. You'll probably get to that.
There's no local rules, right, Erica?
Yeah, that's right. That's right.
No, just DCM rules.
Yeah, just the DCM rules. All right, so we're going to talk very briefly about the court process. So if it is contested, which most of our cases start out that way here at MVLS in my experience, one party is going to file a complaint, whether that's a complaint for custody and child support or a complaint for divorce that covers custody and child support, potentially property. Either can cover also attorney's fees. From there, you have to have service of process. Does anybody know what that is?
Informing the other party.
Yeah, it's a formal notice to the other party, correct. So once the complaint has been filed with the court's going to issue what they call a writ of summons. It's a 2-page document. It looks like it came out of a typewriter, but it is a very important piece of paper.
Yes.
You need to serve that personally on the other party along with a copy of the complaint that you filed. Now, personal service can be certified mail restricted delivery. I do not recommend this method.
Right.
The post office is
Terrible.
ridiculous and
But it's so funny though, like, because people don't really use it, right? The rule says it should be certified restricted delivery. And I had an attorney who was trying to evade service call me up to say, oh, you served me, but you didn't send it certified restricted delivery. And I'm like, but did you get it? So it's just one of those things.
Yeah, but that's a technical argument. But if the box is in check, they're gonna win.
Well, it's not even that the box is checked.
I'm not even
Whether or
concerned
not
about that. The post office. But that was the only person who ever raised that issue.
It's not even that the post office doesn't return it.
They don't
If you
get the
check the box requiring restricted delivery, that means that the post office, the postal delivery person must hand it to the named party on the outside of the envelope, which should be the opposing party. And here's the kicker your clients are going to get. And but they never actually hand it. 9 times out of 10, they leave it in the mailbox. And if they do hand it, they don't get the signature that's required. So there's a green card on the outside that they're supposed to get a signature on that is then supposed to go back to the mailer. Now, here's the other kicker. Your client cannot be the return address on this envelope. You as the attorney may be the return address, your client cannot. Your client as the party to the case cannot be the sender or the server because they can falsify the affidavit of service, okay? You as the attorney can sign it if you certify mail it. Don't waste your time. Please don't waste your time. It's a waste of time and resources.
It's too many problems.
In fact, what you end up happening is 9 times out of 10, you spend so much money mailing these damn things, excuse my French, that you just pay a process server, just pay a process server. Now, in
Get lost.
Judicare world, right, the goal would be to find a third party, a friend, a family member, you know, whatever the case may be, that can hand it to the other party. And then there is an affidavit of service that they can fill out and sign under oath saying they handed the writ of summons. The writ of summons is very, very important. I will say this 100,000 times. Everybody forgets it. You know, sometimes we make mistakes even after all our years of practice in forgetting it, right? The writ of summons is very important. If that is not served, it is not valid service, okay? And then the underlying complaint that has been filed. Those 2 documents have to be served and they have to file that affidavit of service. If an affidavit of service is not filed, the court does not know. You can also pay the sheriff in your local jurisdiction. I think it's $40. Is it 40 now?
I think it's 40 here in the city.
I think, yeah, in most counties it's 40, or jurisdictions it's 40 in my experience. And the sheriff will go out and personally hand deliver. So the difference with hand delivering is you can hand it to any adult resident that resides in the home. As opposed to certified mail restricted delivery that has to be handed to the named recipient on the envelope, okay? So that is the added.
And writs expire.
Yes, and writs expire. That's another important thing. And you have to know your jurisdiction. Some writs expire in 30 days, some writs expire in 60 days. It really just depends on the jurisdiction. When you get the typed piece of paper, or what looks like a typed piece of paper, it will tell you what the expiration date is. The service must happen on or before the expiration date, or you have to request a reissuance of the writ of summons because it will not be valid service, okay?
I've got a question. Sorry. So like, especially for me, working in a small firm, like because I've kind of been taking on family law cases like on my own and just trying to get like outside mentorship, and service of process has kind of been the most difficult piece for us.
It's
Like trying to
oftentimes
figure it out like on my own. So like, what's the most inexpensive way you would recommend to get parties served that meet the Maryland rules? Because I've had clerks come back to me and be like, oh yeah, like that method of service doesn't work.
They also are not attorneys. So let's keep that in mind. The clerks are wrong more often than they're right, in my experience.
Yeah.
And they like to pretend like they know the law, but really they don't.
Yeah.
So the least expensive is to have a third party, not a party to the case, over the age of 18, hand deliver the documents, the writ of summons and whatever the underlying complaint is, to the, most often, the defendant, okay? Then there is an affidavit of service on the Maryland Judiciary Family Law forms.
Okay.
Is everybody familiar with that? Okay, thanks. I like to see head nods. That's good. There's a whole bunch of PDFs. So there's an affidavit of service. There are 2 kinds on the website. Make sure you download the right one. One is for certified mailing. Don't use that one. There's another one that specifically says hand delivery. Whoever is hand delivering it needs to fill that out, sign it under oath. It will include the date and time, a description of the person they served, where they served, the time they served them, what documents were served. I will be very candid with you. When I have somebody hand deliver something, I fill as much of that form out as I possibly can before I give it to them. And then I send it to them with all of the documents so they don't have to print it. Because inevitably somebody screws something up. You don't want to do this 100 times, right? Then I have them return the signed form to me, the attorney, and I file it with the court.
Exactly.
Good idea.
And your second, sorry, Jennifer.
No, go ahead.
Oh, your second least expensive option is the sheriff. So when you call the clerk's office, they will be able to give you the direct phone number for the sheriff in the jurisdiction you're dealing with.
Okay.
Just call the sheriff. Everyone has a different set of rules on how you go about getting it to them. Some counties will let you tell them when you file that you want it to be served by the sheriff.
Right, like
Okay.
on the MDEC, I think there's.
Yeah, there is an option on MDEC. Curtis is right. I don't use it very often.
Yeah.
You have to follow up with them. And sometimes you don't get notice that the affidavit of service has been filed because it's just a little section on the bottom of the writ of summons that the second page of the writ of summons that they return to the courthouse. If you go into the attorney portal where you can download pleadings when your appearance is entered, you'll be able to get it from there if they filed it. They don't often mail it to you, so you don't often know that services happened. That's the biggest, I mean, they have too many things to do at the sheriff's office. I understand why, but it's kind of annoying. They will not get the writ reissued for you though. And sometimes if they make, I think it's 3 service attempts, right? For the
Yes.
$40 before you have to pay a second fee.
Between the $40 for a sheriff and the $90, like what's the going rate for private process now?
Yeah, about
90.
anywhere between 80 and 100.
Yeah, I honestly, and it bites me in the ass every single time because I try certified mail.
Oh, I
It
know.
never works. I know it's not going to work, but you know, when you use someone like Monumental Process Servers, it's all like you can check the status online. They do it within like a week. You know, the sheriff may or may not remember to do it. They may or may not remember to get to file it. So sometimes it's a cost benefit analysis.
I will tell you, usually in my MVLS Judicare cases, I just, as a solo, I just eat the cost.
I do too.
I don't have the time. Because I want to get it done. And yes, I can get my money back, Nancy, and I don't waste my time taking.
Pro bono resources.
I don't either.
No, but here's the thing, if you do have any fees at all, especially with litigation cases, you can always go to the Pro Bono Resource Center and you can request to have it sent to you up front, as long as you let them know what the service is.
Usually with service, you don't have time for that.
You don't.
Yeah,
You don't.
but you can.
Or you can pay it out of pocket, and be reimbursed, whatever you want to do, if you want to save the money, particularly for, this is for MVLS clients, because most of them can't afford a private.
I just want to chime in. I agree with you on filling in the affidavit of service, unless you're doing monumental, those organizations do really good at making sure they have all the
Yeah,
items.
they'll draft you one.
But if you're getting somebody who isn't at that level, make sure you list every document in there, because as I started out saying, you know, some people are really good with their clients that maybe not necessarily be telling the truth. So if they have other alternatives to make your life miserable, they will sit down and they will nitpick at every little thing that you did. Did you do this? Did you do that? Did you do this? Did you do that? And they will make your life as miserable as they can. I will also chime in on, I know we can advance fees. You need to be diligent as an attorney and getting reimbursed for anything that you advance from the Pro Bono Resources Center.
Yeah.
We advocate for clients who are of limited means under the Maryland rules. You can advance their funds, but you really need to make an attempt to be reimbursed, because you don't want someone coming back at you for any reason.
Yeah.
And that is one that you need to be very diligent about.
Yeah. The other thing, I assume, and Nancy, you can tell me if I'm wrong, actually, by not requesting my fees reimbursed, I'm probably affecting the Pro Bono Resource Center's funds for the following year, right? Because if they're, what they have access to is based on the amount of requests from your prior.
Well, it used to be.
I thought about it while we were sitting here talking,
There
actually.
used to be a cap. There is no cap now at all. So you can, they have I don't know where it's coming from, believe me, I don't know, but they have this bowl of money. And
It's a good thing, we need it.
anything that's connected to litigation, and that includes service of process.
Correct.
Any of those fees, and they will reimburse you for it. They've got extra funding, and it's just a matter of filling out a form. Liz Twigg is the.
Liz is wonderful. And you can actually just go right on the website
You can
and
go.
submit
She's
everything.
Amazing.
She is amazing, and she'll get back to you right away, and she'll make sure that your fees are covered.
I
you
will
know.
backtrack before I forget this thought. When you file your complaint, if you are representing the party, as you know what I'm talking about, Curtis. If you are representing the party at the time the complaint is filed, you need to make sure that you file for a waiver of your
Fees.
filing fees and your appearance fees. There is, Jennifer, can you or Nancy circulate those forms?
Absolutely,
Yeah.
absolutely.
There's,
They are on the website.
correct.
And they
Thank
are,
you. Yeah, I will.
if you go onto the Maryland court forms, you'll get those, but ours is specific to MVLS.
Correct.
So you might have a problem the very first time you do it, but then after you figure out how to get yourself the MVLS thing on your
Yeah.
on your profile and all of that.
Yeah, there's a
you're
way
fine,
to
but
get,
it's static the first time.
so in MDEC, there is a way to get a waiver, like in the drop down of the
Yes,
payment methods.
Yeah, that's what I'm saying. You have to go and set that up
Yeah, you
first.
have to go in and set it up. And there, I think, are instructions on the MVLS website about how to do
Yeah, I
that.
was
Very
the one, yeah, I was the
She
one that
was on-
came with it because I had all the problems.
I was on a call with her and Nancy, and I learned that,
Yeah.
yes, and
So does everybody understand what I'm explaining? So when you file and you pay your filing fee, you know, you have your drop down of payment methods and MDEC. You can add a payment profile that is specifically for pro bono MVLS cases, so that every time you go in and file, there is no filing fee. You just select that as the payment option, and it automatically knows when you file that you don't have to pay fees for whatever it is, okay? But you have to set it up the first time, but you always, for your initial filing, always have to file the waiver of the initial filing fees.
It's actually all filing fees now.
Now
the
it's
rule-
new. There's
Yeah,
a
it's
new
new.
rule.
It's a new rule
There's one form. It's
Yeah.
going to be
Nice.
for pre and
published very
post.
soon
Oh, good.
for
I
pre
was
and
getting ready to
post.
follow up with the post, so you stopped me before I got there.
Yeah,
Okay.
pre and post. So when you file that initial form, it covers everything.
right,
Post filing fees, pre-filing fees, just passed by the administrative office of the court.
Oh, good, because it used to be that, do you know when it goes into effect?
October, it was, I think it went into
It might have
effect
already-
October 1st, but the form isn't out yet.
It's not
Okay.
on the.
Oh,
So it used to be
goodness.
that you had to file again at the
$20
close of a
when the
case
client
to
didn't
not
pay,
have to
they
pay
would
the
have to
closing
waived.
fees, but it sounds like the form is getting ready to come out so that once you file initially, you don't have
You
to
don't have to
remember.
do that.
Because that will hold up whatever your final order is.
Correct.
Okay,
Good news. See, we all learned something.
there we go, I did.
So I just wanted to add, sometimes you're not gonna be able to serve the person, right? They may be running away or.
You may not be able to find them.
Yeah, so you can file a motion for alternative service. And you have to show, hey, I've been trying to find this person, sent the process server out, does that happen? And if the court agrees, you can usually like,
Posting.
post or mail it and somehow, like in the newspaper, sometimes that was the way you used to do it.
Yeah, I mean, I've had ones where you like, recently, like you email and text to the last known address and phone number. The one thing,
The form was just updated online and
Good.
it tells, it
Mhm.
lists
Yep.
everything and it's.
so
pretty
I will
perfect.
tell you, the free form on Maryland Judiciary Family Law Forms is a great resource if you need to
Yes.
file a motion for alternative service. When I have those cases, I print the form and I just work my way through as many of the check boxes as I can, because that's a motion, when you file it with the court, you have to lay it on thick. The more service methods you have attempted, the more attempts you have made to locate the person, the more likely you are to get that granted. The first, it seems time consuming, it seems labor intensive, but it's better than banging your head against the wall, because they will reject that more times, off the bat than I can ever.
Yes.
possibly
I'll
And
offer
there's
to
just-
help anybody with that because I do a lot of the uncontested divorces for MVLS that nobody can, like, it's been 10 years and they've been trying to
Yeah,
find the
right.
person or
Yes.
they're homeless. And so I do a lot of, I have 2 of them right this minute that I'm working on. So if anyone ever needs a motion for alternative service, it's pretty, it's easy, but it's complicated. Just please feel free to reach out to me. I have.
Thank you.
That's great. And Erica, and all of you, I just want to make you aware, and I'll send this out to you when we send out all of this. We will, there is an external collaboration site on our website, and I'll send you the link. And if you go in there, there's all kinds of forms and things that we've created. There is an excellent one for an alternative service that we utilized for a client who was, the woman came to us for divorce and they'd been separated for 30 years. God knows where he was. And it took us a year to really get through this alternative service piece. And that form is on the external collaboration, and Erica has some too. So it's there. So I'll give you the link to that and you can look through all kinds of stuff.
And I think the important thing
Forms.
to say about that is a lot of people generally think if they don't know where the other party is, that they can't file, and that's not so.
Right.
They also think that service requires the other party to sign something or accept it, some kind of an exchange. Yes, I've received it. It's not true. And it's important to tell if you have a third party who's delivering it that, yes, they have to see the person in person, but they don't need a signature. And if the person won't extend their hand to receive it, they can drop it at their feet, walk away, the person is served. They can't leave it in the door, but I try to give those instructions very specifically to the client
Yeah.
who's having a third party, because people generally don't understand service because it's complicated. And that's very important. And just as a note on that, when you hire the sheriff goes out wearing a uniform, which oftentimes means that they're not going to get service accomplished because the person just needs to peek out their window, see the sheriff standing there, and they won't do it. So sometimes a third party is a great way to do it, but you have to be very specific about what they can and can't do to get the party served.
All right, we're gonna move on from service just because we're cutting it close from a time perspective. So once a party has been, the other party has been served, as long as they live in state, they have 30 days to file an answer. They live out of state, they have 60 days to file an answer. If no answer is filed, you have to request a default. There's a lot of specific rules about that. I'm not going to talk about it, but I'm happy to walk anybody through it if they have trouble getting an answer filed. The court will not move the case forward if an answer is not filed by the other party and no default request has been filed by the plaintiff. Okay. Assuming an answer has been filed, we're going to operate under that rule because it'll make my life a little bit easier. The next thing that you're going to have is a scheduling conference. That is exactly what it sounds like. It is a court appearance that is non-substantive in nature. What I mean is that there are no real outcomes that are going to happen in your case. You are going to get court services and future court dates at that point in time. There are a couple examples that Jennifer emailed out to you guys yesterday. Read your scheduling orders very carefully. These are the orders that you get from the various different jurisdictions with all of your dates. The two most likely dates you are going to get in most jurisdictions are a pendente lite hearing, and we'll talk about that a little briefly in a minute, and a settlement conference or a pretrial conference. The counties use that term kind of interchangeably. Some jurisdictions will set your trial on the merits at that scheduling conference. In my experience, most of them do not. It's usually your smaller jurisdictions, in my experience, that do that. Your scheduling conference also tells you when your discovery deadline is. It will tell you when you have to note experts by. It will tell you when depositions need to be done. There's all sorts of kind of various different deadlines that are in there. Some counties, cough, cough, Montgomery County, issues the worst scheduling order I have ever seen. They bifurcate their cases.
Drag it.
Nancy is going to cringe when I tell you this. Do not take a case in Montgomery County. If you can help it. You will be stuck in purgatory. They have this philosophy that custody should happen a little bit more quickly than the divorce. Neither of them happen quickly at all. But if you look at your scheduling order in Montgomery County, you will see a section for stage 1, which is custody, and stage 2, which is all remaining issues. You have one set of discovery deadlines and one set of PL hearing for custody, and then you have a whole nother set and pretrial conference, and then you have a whole nother set for your divorce and property. It has never made any sense to this family law attorney because many of the issues are intertwined and nobody can tell you whether or not use and possession of the house is a custody issue or a property issue. I digress.
I think Montgomery County is just set up to make sure those attorneys down there make money.
Okay, well, we can make.
We're very litigious in Montgomery.
They are very litigious in Montgomery County. I don't disagree with that assessment. There are also some very good attorneys in Montgomery County, please don't get me wrong. But I will tell you, it is a very lengthy 2.5-year process to get a full-blown divorce case in Montgomery County, in my experience.
Also, at a scheduling conference, make sure you write down every day, because I was at a scheduling conference yesterday and the order came back. Only 2 of the dates were on the scheduling order. That was it.
You can get, if you get the hearing sheet, that's usually how, because I'm like taking notes and I write down all the dates. And then
Good
you get the
idea.
order and it's missing. And so what I started doing is pulling the hearing sheet, just to like, it's annoying, but that's
No,
that's how
I
that's
think
how I
it's
figured
really
out
good.
how to do it, because otherwise you're like, I know that there's this other deadline and it's on the hearing sheet, but doesn't make it to the order.
So I'm gonna tell you, I'll answer your question in just a second. Here is my favorite trick, and this is how I know there are rookie attempts in counties. Read your scheduling order carefully. Most counties include depositions in your discovery deadline. That means your records depositions and your depositions of your parties. Some counties excuse it. Please pay attention. Howard County, Erica's making a face at me. Howard County excuses your depositions from your discovery deadline, and people do not realize it. And I have been known to note depositions, a month before trial, because I know, as somebody who has practiced there my entire career. So all of that to say, read your scheduling orders carefully. They are like the Bible for your entire case. And, there are, Anne Arundel County, you don't get discovery in by the end of the discovery deadline.
And that's what confuses people. Maybe you want to explain what the discovery deadline
Yeah, so
really means.
Yeah, so that's the other piece. Yes,
Yes.
correct. So if you don't get your discovery completed, okay, so discovery, interrogatories, request for production of documents, request for admission. It's really your fact-finding ability in a case, right? Parties have 30 days to respond to discovery. Request for admissions is always 30 days when the requests are deemed admitted. That is a very important one that many people don't know. Please respond to them in 25 days.
But
These
it
do not
doesn't
wait.
matter,
Yeah.
because when you do to go move them to have them admitted and they get answered after the fact, they're like, no harm, no foul.
Nope, I file a motion to have them deemed admitted under the
Yeah,
rule.
but I've
No,
had
no, no,
judges.
that's what I'm saying.
Yeah.
You file a motion, the other side then answers and they're like, oh.
So the problem
counsel.
is when it deals with
Custody,
custody,
it doesn't
absolutely.
matter.
It does, nothing matters in custody. Custody is like rogue world, okay? And I'm happy to talk about that in a minute too. But the general rule of thumb is discovery must be responded to in 30 days. If you have a discovery deadline, that means that if somebody didn't respond in 30 days, your motion to compel has to be resolved,
Correct.
which is the motion to the court asking them to step in, because discovery is usually self-guided and self-directed, right? To get them to compel discovery, and often your motion to sanctions needs to be resolved by then too, okay? What that means is if you have to file all of these motions, you have to start your discovery usually before your scheduling conference date even shows up in order to comply. Some of them carve out specific exceptions that go beyond the discovery deadline for motions to compel, motions for sanctions, those sorts of things. This is back to, please read your scheduling order. They are all different. In Arundel County, you have to file your motion to compel 18 days before your discovery deadline. Why 18 days? Because they have to have an opportunity to respond, right? Means court won't have ruled on it. But if your motion to compel is not filed by then and you file it after that 18th day, I'm filing a motion to strike and they will strike it. You are up the creek without a paddle in your ability to get discovery. Their discovery deadline also covers deposition for records or subpoenas for records depositions. That means if they're not issued by then, you don't get those records. It can be very, very problematic in your cases.
And
So-
for your ability to practice law, because theoretically, if you
Yeah.
don't do and get discovery
Correct.
and it jeopardizes the result of a case, you could theoretically need to notify your malpractice carrier.
Correct.
True.
Yes, and the other thing is that, as you said, you're not going to do well or succeed in that case if you do not do your discovery, because that is the crux and bones of forcing a settlement.
That's how you learn your clients are lying to you, Michelle.
That's right.
That is it, right? I mean, that's how you prepare to defend your client, right? Like, I always explain to people, this is arguably, other than a multi-day trial, the most expensive part of your case. But it also allows me to be the most prepared, to give you the best
The most
advice I
necessary.
possibly can. Because not only am I learning evidence that is beneficial to you and your position, I am learning what the other party knows about you and what they're going to say about you, which allows me to better defend you as my client. So it's kind of a two-way street, and it does a lot of things for me as an attorney. And I always tell people, please don't summarize what your discovery says. I want to read it with my own fresh set of eyes, because my legal expertise and my legal experience is going to tell me something than your clouded judgment, your clouded, understanding of what happened. I'm going to read it and I'm going to hear something completely different about what happened between mom and dad than you as the client, because you're going to make it most favorable to you. I want to see it from the eyes that the court is going to see it, right? I want to be able to see both sides of it, because that's the best way I can help you. We need to have a conversation about, maybe you shouldn't be talking to mom like that. Let's change the fact that her name on your text messages says bitch. Please, let's change this. I can see it when you screenshot it, right? Like, if I can see it, the court can see it. We have to start fixing these things. So discovery is incredibly important from kind of all of those sorts of perspectives, and knowing your discovery deadlines in these scheduling orders are incredibly important for those reasons. Go
Well,
ahead.
there's a few practical matters, because I get in these, a lot of times I get a client who calls me after the discovery deadline, or when no discovery's been done. Or essentially there's like, as I see it, especially with pro se litigants, there's the law versus what actually happens. Because honestly, you can file all the discovery you want. And like in Baltimore County, if you don't even file the motion to extend the deadline or file your motion within 30 days of the deadline, then they will deny. And in some counties, even if your discovery deadline is say in October, but by the time you have a settlement conference and you pick a trial date 6 months later, and there's everything's new, whatever, that's still beyond the deadline. But people always send trial subpoenas a week before trial, demanding their documents at the last minute, because as a catch-all. And most courts don't, look the other way and don't say, hey, that's beyond the deadline. Because or essentially your client a lot of times owe you money or can't afford to pay for that discovery or to fight the motions. And you're basically doing everything on a shoestring budget to try and help people. So I mean, that's why discovery is a necessary evil, but you have to sort of balance, are you close to settling the case? Or can you maybe work with opposing counsel? I mean, I know it doesn't really apply with MVLS cases per se, because more often than not, they don't have the money for that. And as much as you would file discovery, your chances are you'll never get those records. And I've tried so many cases when even if you send discovery or didn't send discovery, you're not gonna have anything at the time of trial anyways.
That's the truth.
The other piece about discovery is if you propound discovery in a timely manner, there is a rule that says that there is an ongoing duty to supplement. Those are my words. Ongoing duty to supplement discovery.
Yes.
But the only way somebody can supplement is if you timely filed it, timely propounded it in the first place, right? So that would be the one exception to the discovery deadline. And what you'll see is a lot of times during the pretrial conferences, and we'll get there, that pretrial order will say that supplementation of discovery is, pending trial, right?
Yeah.
All right, your pendente lite hearing, that is pending litigation, it's Latin. It is intended, it can cover, sorry, I'll backtrack. It can cover custody, child support, alimony, use and possession of the home. It is not going to divide property. And at the scheduling conference, they will ask you generally what issues it should cover. It may also include a request for attorney's fees as well in some jurisdictions. You have to be very careful. Usually these are anywhere between 1, 2, and 3 hours in most of your jurisdictions.
Around 2 hours right now for one in Baltimore County next week. What?
Yeah, yeah. Well,
I'm sorry, 2 days. Did I say?
2 days?
days?
You got a 2-day PL hearing?
Ask me how. I inherited this case. I thought it was for a final trial until I just learned it was PL.
Okay. Lucky you. Most jurisdictions, you're never going to get a 2-day PL hearing. You're not even gonna get a full day PL hearing.
That's what I thought.
Anne Arundel County, if you don't have, if you only have one limited issue, we'll give you 1 hour. I cannot open my mouth in 1 hour. Let me be clear. What can you say in 1 hour, right? Like, I mean, you get 5 questions because that includes your case in chief.
That's the way they are there, though.
Yes, I practice there every.
You cannot go over that 1 hour either.
No, they will put a game stop clock on the.
Wait, 1 hour per side?
No. Ma'am, 1 hour.
Both sides, you get a half.
I'm telling you, I cannot open my mouth in that 1 hour. Like what do you ask? 5 questions? I mean, you have to have,
Plus your closing.
yeah, plus your opening, plus your closing. I mean,
You have to include that all within your half hour.
correct. That's absolutely correct.
That's Anne Arundel County.
Talk quickly.
They don't mess around.
Most jurisdictions you get anywhere between 2 and 3 hours. You can file a request for a full day PL hearing if really necessary. Most of the magistrates don't want to hear it, and most of them don't have the time on their calendar. It is more often, in my experience, that those requests for longer PL hearings are denied. PL is really just intended to put a Band-Aid on the case. It's to stop the, picking up the child from school early because there's no agreement on when the child should see mom versus dad. It's the one parent is not paying child support to the primary custodian kind of scenario, right? It's in our MVLS cases, somebody needs alimony, right, in the middle of the case so that they can pay their bills and put food on the table. It is often a great spot to get attorney's fees if you don't file a separate request for attorney's fees in a case. Obviously in MVLS world, the likelihood of that is pretty slim, but I mean, you can get attorney's fees in a pro bono case, so keep that in mind. There is case law that says that. And then daily day hearings, go ahead.
The question I had, are they like, because I'm down in Southern Maryland and I've only had one, but it was like for an emergency custody and like a protective order hearing. Are they like normally scheduled within like child custody modification cases and divorce cases, or do you have to like file a motion? Or like, for example, I have a case right now where the settlement has been delayed for so long. And I'm like sitting here and I'm like, do I need to file a motion for a pretend daylight hearing because the other party's like not paying child support?
So in my experience, and other mentors, please chime in, usually I have seen that in a modification of custody and child support, because there is an underlying order in place, that you're not gonna get a PL hearing.
Okay.
Usually where you see them is in an initial custody case, an initial child support case, an initial divorce case with children.
Okay.
Because there's nothing to tell the parties and they're kind of in no man's land, right? That's different than emergency, right?
Yeah.
Emergency is, for lack of a better word, there's blood on the wall, right? I mean,
It's gotta be like,
some count, so we were talking about DCMs a little earlier. DCM is your domestic case management plan. Every county is supposed to have them. Most counties publish them on their websites. Some counties don't have them. Some counties are very, very outdated. It is your rule book for that county. There are no local rules according to the Maryland rules. I am here to tell you there are local rules. Know your jurisdiction, find yourself a mentor or an attorney you can ask in that jurisdiction. Okay. That will tell you what constitutes an emergency. Every county's definition of emergency is different.
does Anne Arundel County still do the, like emergency hearings, like in August for school?
Yeah, some counties have rocket dockets in August for school or in December for holidays.
Who else does that? Because I haven't. come across-
Baltimore, does
Harford
Baltimore County
County.
still do them? Harford County
Yeah.
does them.
Okay, but Baltimore County, Baltimore City.
There's usually an email
Howard County, they
in
don't-
July giving you like by August 14th or something. They have a day or two that they do them.
Anne Arundel County, Harford, in my experience, Baltimore County will do them. If you're part of Baltimore County Bar Association, they will send an email out about it usually. Howard County does not have, we call them rocket dockets. It's when there is a dispute about what school a child should be enrolled in, or if there is no holiday schedule in place, what the holiday schedule should be right before Christmas usually or Thanksgiving. We jokingly call them the rocket docket because they're very quick, very brief hearings. They're like mini PL hearings essentially. Howard County does not have one, but I know I have good on good authority because I've done it before, that if you file an emergency there, some of the magistrates will entertain them.
And those emergency hearings too, my experience in 2 cases was that even though it was quote unquote an emergency, it took a while to get on the court docket. And so do not think that just because you file for it, you're going to immediately get a hearing.
And what many attorneys don't understand is there is a difference between emergency and expedited.
That's right, right.
Expedited means you don't have to wait 60 days for your PL hearing.
There's,
Emergency usually should happen within like 10 days, within 10 business days.
there's service requirements. I would think just if you're a mentee and you have an emergency situation, please talk to your mentor.
And I will tell you, start with your DCM. If you need a DCM, email me. I have every one of them in my computer.
Very nice.
Yes, I have all of them saved to my computer because I mean, what happens, and it tells you the life cycle of a case. That's the nice thing about the DCM is it will tell you kind of the local practices and how a case will go through the system in that particular jurisdiction. But they are especially important in emergency and expedited situations. Sometimes I look at a case and I know I can't wait 90 or 120 days for a PL hearing because there's something that is more imminent, but not an emergency. And I will just immediately, with my complaint for custody, divorce with children, whatever the case may be, file simultaneously a motion for an expedited PL hearing and explain why. I will tell you, in my experience, they're more often to give it to you because you are acknowledging that you are not wasting time on the emergency docket for something that is not truly an emergency. But you have to really use your discretion, right? You have to practice in front of these magistrates and these judges. Use your discretion, be mindful of the time that they have on their own dockets, okay? While we're talking about PL hearings are generally heard by magistrates. Does everybody know what a magistrate is as it relates in comparison to a judge? Okay. Magistrates, just for my edification, are family law attorneys usually, or sometimes they are juvenile attorneys or state's attorneys that have juvenile work that have been appointed by the administrative judge in a particular jurisdiction to hear certain types of family law matters. There is a rule about what the magistrates can and cannot hear. One of them is anything else the administrative judge says they can hear. So it's one of those wonderful catch-all rules. But usually it is your pendente lite hearings, your custody, non-divorce custody hearings and child support. They can hear contempt hearings generally. Some jurisdictions will let them hear requests for attorney's fees if that's filed as a separate motion. Magistrates are not judges. When they hear a case, they make recommendations. They make findings of fact and recommendations. Those recommendations are just that. After you receive a written copy of your recommendations, you have 10 days to file exceptions. Exceptions are essentially an internal appeal period where if you believe that the magistrate got it wrong, you can file exceptions and a judge will hear why you believe the magistrate got it wrong. The judge then has the opportunity to either change the ruling, send it back to the magistrate, or uphold the recommendations. I said ruling, I apologize. If nobody files exceptions, those recommendations become your order, okay? They become binding on the parties. Parties can waive exceptions. Magistrates generally hear uncontested divorce hearings, uncontested custody hearings. I see you. So it is not uncommon, especially if there's a settlement agreement, for example, you were asking me this question a little bit, that the parties will waive that exceptions period because there's nothing really for the magistrate to do. They're just taking testimony that the parties have been living separate and apart, or that it's a mutual consent divorce, for example, and that this agreement should be made part of a court order, okay? Go ahead.
Yeah, so I was just gonna make mention to the exceptions piece. The exceptions are for testimony or evidence that was presented, not stuff that you should have done during.
Oh, correct, yes. I'm
So I
sorry,
just
I
wanna
didn't
make
make that
that
clear. No, I appreciate that. That's important.
Yeah.
Right, it's limited to.
It's literally like a mini appeal.
Yeah.
I mean, for lack of a better way to describe it.
And for those of you who are doing MVLS cases, you are not required, we don't really support, you're going beyond the basis of the original matter. You do not have to take appeals or exceptions on the case unless you choose to do so. But generally speaking, because the reason for that is they're not usually successful.
Yeah.
And so it's not something that we support.
Right,
As a
mainly
general
because
rule of-
it's only, a lot of times what people want to do is try to bring in extraneous stuff after the fact.
Yeah. And there are
Especially when they've tried the PL hearing or the custody issues without representation, then they say, well, I should have said this. No, it doesn't matter.
Yeah.
You were treated the same way us as an attorney were. Go ahead, Rich.
I was just gonna say though, when you're doing a case, even for the MVLS, you might want us to file what's called a limited scope representation
Yes.
with an acknowledgement of the limited scope, because the problem is when your client then files the exceptions, you're still the attorney of record.
Yes.
The court still looks at you that you're supposed to respond, and then the burden's on you to either send a copy of your MVLS agreement or fee agreement. Hey, I was never meant to be in this, and then you would file your motion to strike, and then the court would usually defer the ruling on that at the time of the exception. So you're trying them anyways. So that's why you have to. I'm just saying that happens. You're the only attorney in the room. Court tends to find, especially in Baltimore City, they'll find a way to keep you in the case regardless.
If you file, I do have a quick question for through MVLS. If you do, say the judge put in $600 a month, but the other person's income was 6,000, like a true error. Who pays? Because the transcript request has to be filed at the same time as the request for exceptions.
You can you can ask the Pro Bono Resource Center.
Okay, they would pay for a transcript.
Yes, and if it's really an expedited issue, in my experience like that, you can, Twig, I think is her last name, Twig, thank you. If you email her directly and explain to her what's going on, sometimes she can fast track like the typical approval period so that you as the attorney aren't fronting the money, although frankly, those transcripts tend to be less expensive, thankfully, but I mean, especially. if
Not on my
strike-
2 days. They wouldn't
Not on your 2 days.
No.
Here's the hoping.
But I was just gonna mention, if it's something like that, because I have had that where there was more like a typo, like there was an extra zero or something like that. I just notify the clerk, I just call the clerk and say, hey.
Yeah, correct.
This is what happened. They just go in there and fix it.
Sometimes you can actually even call the magistrate's chambers and ask and know.
No, that's what I meant there.
Yeah, if you, especially if the other side agrees, I mean, you could notify, I've done that. Yeah, if you have an unrepresented party,
I was just trying
obviously,
to, yes, I
yes,
was trying to
yes.
make it very basic, but
Yes.
I was just curious who.
Yeah, I would email Liz
If you go out,
for like a more expedited.
if you go out to the Pro Bono Resources Center, there are guidelines on there for the Pro Bono Resources Center reimbursements. They're excellent.
Yeah.
You should download a copy, have it on hand, and know what you can be reimbursed for, and always ask for your reimbursements.
We'll send that out to everybody too, so that everyone has it, but that's, I just read that myself and thought it was very
It's
handy.
excellent.
And if you're not sure, call anyway.
Always call Liz.
Yeah.
Or
She'll
email,
work it
yeah,
out.
email her too. She's pretty responsive to her emails.
Yeah.
After your PL hearing is generally your pretrial or your settlement conference. Usually it's like another version of mediation. You often meet with a retired judge. Sometimes in the family law cases, you'll meet with a magistrate, but that person is not going to hear your merits trial if you cannot resolve it. It is an opportunity for somebody in a more authoritative position or role to kind of say, well, if this case were to come before me.
That's
this
why I always
is
say,
what-
talk to my client.
Yeah,
please.
this is what I anticipate the outcome in this jurisdiction might be. It is often very helpful in my experience, especially if you are the one with the client that it has unreasonable expectation.
Oh, man.
So
Yeah.
in private practice, when my client is paying me, they're much more inclined to listen to me, although they still sometimes don't listen to you. I'll be very candid, right? Like you're paying me for my advice, but you don't want to listen to it. When you pay me $400 an hour, you're much more inclined to listen to my advice as a private practice attorney. These pro bono clients, they don't have that, right? They're not paying for your services. They don't understand what that comes with. It's not the same mentality, I hate to say. And so sometimes they don't give your advice, your counsel, the weight that it really should have, right? So it is very helpful in my experience to go to these settlement conferences and have the judge, the retired judge, or the magistrate sit and talk to your client. Because sometimes that judge or magistrate, especially if they give the same piece of information you've given 100 times, they're in a position of power, right? Or perceived power. So the client is often more likely to listen and take that advice, even if they never say, oh, I should have listened to you, right? There is something to be, my favorite thing is when I go to these settlement conferences, I'm like, oh, that's just what I told you, right? Like, it's very.
And I say it too.
And sometimes I do too, like, you know, sometimes I do too. It certainly depends. But it is often very beneficial. Sometimes it's beneficial for the other party because they're the one being unreasonable. If you've done your job as an attorney and managed those client expectations, the hope is that it's really the other party that's being unreasonable and preventing you from reaching them. So.
I use my client as like the guinea pig to get the other person to talk to.
Correct. Yeah.
The other side, because I know what's the other side more often.
Yeah.
Because I check mine.
If I've done my job, you're exactly right.
Although Google gets in the way.
So with the settlement conference, there's no testimony taken at that.
No, it's very informal. You often go back into what we call the senior judges chambers. And you just sit at a desk or a conference table with the retired judge or the magistrate. And if the other party is unrepresented, they will generally bring everybody in at one time, just so that there's no sense of impropriety in my experience. If there are two attorneys, it is not uncommon for them to separate the two parties and meet with like just the attorneys or an attorney in that one party and then the other side and their attorney. So it really depends. It also depends on the magistrate or the retired judge's, you know, personal preference, just like in mediation or anything like that. It's very similar to mediation with a slightly more elevated position because you have somebody, especially in some of your bigger counties, you'll have somebody, a retired judge from that particular jurisdiction that has been there recently, talks to the other judges, talks to the magistrates, and can really, you know, put a thumb on a case and say, like, look, this is what you're facing, this is what's going to happen, right? With the exception of the smaller jurisdictions that give out merits trials at the scheduling conference, if you do not resolve your case at the settlement pretrial conference, that's when you'll get your trial date. Some counties, that's pretty quickly. Some of your larger counties, that could be 6 months, okay? I think we'll go with this slide now.
Yeah.
I talked a lot, and in fact, I think I
You said a lot
actually,
of great stuff.
I think we can go past this one. Okay. It's okay. All right, grounds for divorce. We'll do this very quickly. You have 3 grounds for divorce. Thank goodness Maryland came into 21st century. Mutual consent. What that means is that the parties have a written agreement that resolves all issues between the two of them. Obviously, this is for divorce cases only. So property, child support, child custody, alimony, even if it is a waiver of some of these things, it has to be comprehensive so that the court knows that all issues are resolved. Even if it means there's no exchange of alimony, even if it means that there is no exchange of property, it needs to be noted in there that those things are not happening so that they know that all issues have been resolved. So mutual consent, both parties have to consent to the divorce. It used to be that under mutual consent, both parties had to show up at the uncontested divorce hearing. A lot of magistrates still want to act like that is the law. It is not the law. Please point them to the statute that says that only the moving party has to be there, provided that the other party, the defendant usually, filed an answer consenting to the divorce, okay? 6-month separation used to be that they had to live separate and apart, and what that meant is under different roofs. Now they can sleep in separate bedrooms as long as they're not having sex. That is the caveat. Most parties forget to tell you that, oh, we are sleeping in separate bedrooms, but we still had sex last week. Make sure you ask that very specific question.
Have you?
Yeah. You're not wrong, because inevitably what happens is a divorce hearing, the judge asks that question if there's been no marital relations, and then somebody says, oh yeah, we had sex last week.
I've had a case like that.
We've all had cases.
I'm like, what are you doing here? It's like, it's not over.
Some people are dense and don't understand what marital relations mean. I will be very candid in that. Don't know how many times people are like, what does that mean?
Sex.
Did you? Family law, you have like the most interesting conversations. All right, the last one is irreconcilable differences. This came to light last October. Did I do this right? Last October, right?
October 23.
23?
Yeah.
Oh my goodness. All right, I'm old. Irreconcilable differences. Does anybody know what this means? One party doesn't want to be married.
Yeah.
We don't have any case law here, right, to direct us as to what irreconcilable differences is. I'm not aware of any appellate cases that have come down to really direct us on this.
No, essentially, it's just a catch-all, essentially, that the marriage is irretrievably broken and over.
One party can just say, I don't want to be married. I mean, it is.
But by the time you get to
simple as that.
court, you've already either had been separated for 6 months or you've had an agreement, so it would just transfer or convert it orally to a different.
All of these are options, okay? again, if you think the magistrate or the judge isn't gonna get the irreconcilable differences, you can amend orally on the record for 6 month separation, because most likely they've been separated that period of time. Annulment means that it is though a marriage does not exist. I have filed for one of these in 15 years, and in fact, I was successful.
Me too.
On a
One in 20
contested
years.
annulment,
Wow.
on a contested annulment in Anne Arundel County.
That's
If
good.
your client is insistent that you file an annulment, my practice is generally an annulment or in the alternative, a divorce. Because what happens is you don't want to go through the entire annulment case, get to the end and have it denied and have to start all over. Some attorneys believe that filing in the alternative undermines your annulment claim. Some attorneys don't. Again, other than the one case where I was completely successful in my annulment attempts, I have seen every other annulment converted to a divorce at some point in time, because eventually you can convince your client that that is the more successful route. When I first started practicing, annulments were a lot more popular because of the religious component of it. I think the Catholic Church especially has really relaxed their requirements in my experience, as it relates to the need for an annulment for a second marriage, for example. And so I just think you're not seeing these nearly as much as you used to. I really discourage people from filing them. The court doesn't know what to do with them, candidly.
Yeah, and the legal basis is so narrow. So many people think, oh, I only married for a week, but that's not a basis for an
No, you
annulment.
have to look at the contract law.
Right.
I mean, it is very much contract law based.
Yeah, mine was based upon, I represented the PR on behalf of the husband, because he had dementia at the time that it was signed. Because his caretaker became his wife.
Oh, for inheritance, the annulment was.
Because he owned a home.
Yes.
Mine, yeah,
That's a good one.
Mine.
So that one was, I was compelled.
Mine
That
was
was a
in
good
St.
one.
Mary's County, for all you St. Mary's County people, actually. The parties lived in St. Mary's County. My client ultimately moved out of the house and filed in Anne Arundel. But the husband was embezzling a bunch of money and was arrested by the feds, and the wife didn't know any of this, and she had married him on the proposition that they were going to have this baby, because she was like older, she was like almost 50, I think, and the proposition that she was gonna have this baby, and they were gonna go through like fertility treatments and stuff, and like 3 weeks after they got married, he was arrested for all of this like major like federal embezzlement and things of that nature. I don't know, it was like in the Washington Post and the whole 9 yards, and I was like, this is clearly fraud, guys. Like he knew, he knew this was coming down the pipeline. He knew they were investigating him. He knew he was never going to have, go through with the IVF and those sorts of things. And thankfully the court agreed with me. But I mean, annulments are really extreme cases, right?
Those are two perfect examples.
But there's not many of them.
No.
Alimony. So there's 3 types of alimony: pendente lite alimony, which is temporary pending the case. The threshold for that is very low. Need versus ability to pay. In my experience, you're more often to get PL alimony than you are to get rehabilitative or indefinite alimony. At marriage trial, you can get rehabilitative alimony, which is exactly like it sounds like. It's intended to get the recipient spouse back on their feet to become self-supporting. That is the more preferred type of alimony. Indefinite alimony. When I think of indefinite alimony, I think really old school, like my grandma's generation, where she never worked, my grandfather worked, my grandmother raised children, and then he decided to divorce her in retirement. Well, or shortly before retirement, right? Like she has no skills, she was not marketable, she could not go out and earn a self-supporting wage, those sorts of things. Sometimes you see it in these really huge income disparity cases too, where one spouse earns $1 million and the other spouse, has a high school diploma, right? So you might see it in those sorts of instances. You're not going to probably see it in your MVLS cases, but we'll touch on it while we're here, okay? When you get to merits alimony, there are factors the court has to consider. They're very similar to the property factors. They are not identical, but they are very similar. I highly recommend that you go to the statute. The statute is kind of the basis for what you need to demonstrate before the court. Can we? Sorry.
Oh, yeah, sure.
Okay, I'm sorry, yeah. We talked about PL is status quo, making sure the mortgage is being paid, that somebody can, pay their attorney's fees, pay their, utilities, those sorts of things. Nope. If you file alimony, you need to file a long form financial statement. There is a copy in the materials. It's also on the court website. If anybody has any questions about how to fill out the long form financial statement, they can be complicated. There are no real rules. Every attorney does them differently. The thing you need to keep in mind is that your client, when they get on the stand, has to be able to explain it. So if you got creative, I highly recommend footnotes, because I can always show my client the footnote page that I filed with the court and say, can you please tell me how we arrived at this sum in a particular line item? Footnotes are your friends. Nobody's going to be mad at it. Okay. Long form financial statements, any financial statement really is signed under oath that it is truthful and accurate. You can always amend them as your client's finances change throughout the course of the case. The other thing you need to know is sometimes for argument purpose in closing, I will mock up a long form or a short form financial statement for the other party if I think their financial statement was not accurate. Okay. We talked about these. Go ahead. Division of property, not often in your family law, in your MVLS cases, but marital property is property that was acquired from the date of marriage to date of divorce. Nobody likes that. Everybody thinks it should be date of separation. Well, too bad. Maryland law says it's date of divorce, which means that any retirement, for example, any money that is earned during the separation, that is also marital, subject to division by courts. Anything earned prior to the marriage is non-marital property. Anything earned after the marriage is non-marital property. If one party is claiming that an asset is non-marital or has a non-marital component, think retirement accounts. Somebody worked for years before they got married, had retirement funds coming into the marriage, and then continued to contribute to that retirement account post-marriage. That is a mixed asset. It is both non-marital and marital, but the burden is on the party claiming a non-marital component. That is very, very important to demonstrate to the court. I was working here before I got married. Nobody gives a crap. You need a piece of paper that says it and what the value was. Just because they say it doesn't make it true. I start in my initial consultation and my first client meeting asking this question. If that account is more than 7 years old, you are going to have trouble getting those records. You have to work and work and work and work and work to get them. Okay. So you want to know that piece of information very early on. If you can prove it, the court will let your client keep that portion of the asset, okay? The joy of all of this is if you guys and the clients agree, or the parties agree, you can do whatever you want, right? The hope is that we have two reasonable parties that say, yes, husband brought this into the marriage, wife brought this into the marriage, and we both agree that these are the non-marital values of those accounts. Sometimes it takes giving that document to the other side in settlement negotiations to get you there. But a good attorney, a Rich and Erica, any of us, right, are going to look at that document and say, it's pretty likely the court's going to agree with them. There's no point in fighting over this. You're just going to pay me a ridiculous amount of money to fight over, something that's not going to change the outcome, right? I mean, I can be compelled. If I can be compelled as opposing counsel, the likelihood is, in all of my years of experience, the court's probably going to be compelled too, right? You need a statement that is close to the date of marriage as you can possibly get. Sometimes that's harder than others, okay?
What about that home that was acquired prior to?
Yeah, the home's the hard one. You gotta have an expert usually that will appraise it as of the date of marriage. If you can find a real estate appraiser that does estate valuations for probate work, they can also do it for marital property purposes. They are very used to backdated evaluations or appraisals, I should say. Not every real estate appraiser is good at backdated real estate appraisals. Okay. You need to find somebody who has experience in this area. The other one that you often get is, well, I sold my non-marital house and we bought this house jointly. Sorry, you just gifted that spouse that property. Nobody likes that answer when it becomes jointly titled. Or if I owned my house prior to marriage and then we refinanced and we retitled this house jointly, the minute it becomes T by E, you lost that money unless that person's a good person. okay? You, go ahead.
Wait, I'm a bit confused from.
Sure.
I'm sorry. I know it's coming back
So
to me.
is everybody else. So is everybody else. Don't worry.
So, because you just asked about the house, so because what I just read on the slide, so if you own the house before marriage, isn't that your property?
It
How does it
depends.
become-
It depends. This is law.
This is law. It depends.
How does it become the joint?
Okay.
Is it if you refinance during?
Not even just
Not
refi-
just
so
That's excuse.
again, just like a retirement account, if it was owned by one party prior to date of marriage, it has a premarital, non-marital component.
Yes.
Even if you never retitle it,
Mhm.
any income that comes into either party during marriage is marital property,
Mhm.
which means that whether husband's income, wife's income, whoever the title owner, it doesn't really matter, paid down the mortgage during the marriage, you have now created a hybrid asset that is both non-marital and marital. If you can't tell, I love property. Okay, it becomes very difficult because then you have to have that appraisal that is both the current value as close to the date of divorce as you can get, and the non-marital value as of the date of marriage. Okay, to determine what the growth was. Now, the problem is there's a lot of moving factors, the housing market, all of those sorts of components can really come into play. The same thing with the stock market on your retirement, but I'm being simplistic here, okay? The difference is if any point during this marriage, these parties refinance the original mortgage and that individual owning spouse then retitles the house, you have gifted under the law the non-title owner all of the premarital or one half of the premarital equity, which means the house is solely marital at this point.
Yeah, but the good part she was talking about just before then, with the funds and both contributing, even though the name, the house wasn't retitled.
Yeah.
It's still that.
Correct.
Other
You
parent, that other,
created a hybrid asset.
yeah, they still have a marital interest. I actually have that going on right now in Montgomery County.
Yeah, it takes a lot of work on a spreadsheet to actually determine exactly how much.
But I
was
do
in
need a good
premarital.
expert.
And for the mentees here, I think there's a really big value in knowing what cases you shouldn't be handling. And to be able to say.
Look, I shouldn't be handling this one.
I do think, it's very tempting sometimes when you get a client, especially if you're trying to build your practice or get into a new area. But these complex marital property cases, I would venture to say, even with a mentor, you probably shouldn't be taking them. The risk is too big for you if you don't have a great understanding.
Yeah, those are.
Thank you,
that's
Carrie,
a
get out that
very,
case.
very
Is that what
difficult
you're telling
case.
me? Carrie, get out the case.
Yes.
That was my.
Sometimes I feel like I should get out of these cases.
That's what I'm saying. Somebody tell me to get out, please.
But property is complicated. In an MVLS case, if they
You're not
have
gonna have
this kind
it.
of property,
You're not
you
gonna
can't
have
take
the
them.
client.
They're not MVLS clients anyway, so
Yeah.
this is not what you're learning on.
Yeah,
This
you're
is just
only-
family law 101, okay?
Yeah.
Go ahead. Did you have another question?
That was my quick question was, you've mentioned a lot, you're probably not going to see this as an MVLS case. So what kind of cases are we usually seeing?
Usually custody, child support, just straight divorces with no assets.
Okay.
And
Usually
limited
not an
means.
alimony case, because more often than not, in MVLS, both parties would arguably qualify for MVLS.
Sometimes
And if you
retirement,
think about-
retirement cases, you might see pension in
Sure.
long-term merit, in MVLS, long-term
Correct.
marriages, you might see retirement.
If you have pension and retirement things, please call me. I draft quadros all day long.
Yeah, she does.
Yeah, please call me before you
Here's the
step
issue
in
with
something you shouldn't
MVLS,
step into.
Cases is that sometimes we'll get a client that will want to access our services and they are so poor, they have nothing. But the opposing party has assets.
I'll be right back.
A home in wherever, worth $500,000. Those cases we don't take because they have the, in assets, the ability to, they're likely going to get some of that. And so we get some over income and it's a very difficult time for us to let those cases go. But it is what it is.
Yeah.
Interesting.
So we
Yeah,
won't
that happens a
accept
lot.
cases
I think our challenge is
over
more on the other side.
What is it? Over,
If that home is valued at over $300,000, we reject them.
we
So
reject it.
there's a home involved, it'll be below that.
I think our challenge in low bono, pro bono cases is which is what we take here.
Yeah.
that we are on the other side of how do we support this client through the legal system when they probably need a BIA, they probably need, maybe they might need a medical expert, they may have other needs that they need. I think those are our challenges.
Well, the other thing about that, real estate appraisers, if you ever would need one, the cost of a court reporter. What was the other thing you just said?
Medical.
Yeah.
Yeah, medical experts.
Medical experts, they are all worth calling the Pro Bono Resource Center Litigation Fund. They will cover that. Because they, as I said, they used to be a cap of $1,500 per year per case, but now it's open. So they'll give you more than that.
Yeah, and I think that's what we're looking at is when we're representing MVLS clients, we're looking at where can we get the resources that they need,
Right.
be able to withstand the litigation because they don't have the funds and they don't have the assets that they could sell to get the funds.
Yes.
And each jurisdiction like has, you know, special situations like for when a BIA is needed and the party can't afford it. Like I know like Calvert County specifically like has a waiver and they will pay the BIA's fees, like if the parties can't afford it.
Every jurisdiction has their rules on that. And you have to, it's like going back to what she suggested is going back to the case management plan to find out for sure what the county is going to do because they all have their own set of rules for those.
Yeah.
And you can get tripped up in your case if you don't know their rules.
I'm trying to talk very quick. You're doing awesome. All right. Anybody else have any questions about property or anything before we move on? And I'm sorry, I had to step out. I couldn't hold it.
All right, you get to leave.
Yes, I'm sorry. All right. For alimony and property purposes, if the court is to divide or award alimony, the court recognizes both the monetary and non-monetary contributions. That's why a spouse who didn't work during the course of the marriage would be entitled to alimony. Their non-monetary contributions afforded the other party the ability to go out and earn all of that money that he or she earned. You know, especially in an instance where they raise children, there's a lot of money in that. Think about how much parents pay for daycare, right? So keep that in mind. A lot of people think, oh, well, it's in my name. She didn't work. He didn't work, whatever the case may be. Therefore, it's mine. Nope, those non-monetary contributions are just as important. All right. So there's two types of custody. Physical custody, which is where the child lays their head at night. Legal custody is decision-making for major decisions, religious, education, medical, the other general welfare of the children. It's not the day-to-day. It's not how much TV do they get to watch. It's not whether they have access to a cell phone. It's not, you know, whether or not they take a shower every night at that parent's house. Nobody cares about that. That's up to the physical custodian during that time. There is an initial establishment of custody, both physical and legal. Back to the PL hearings, you need to know whether or not the court is going to enter a PL order on both physical and legal. Some jurisdictions do not address legal during the course of a PL hearing. Some jurisdictions do. So know your county, know your city. You can also modify. Custody and child support are the only portion of a divorce with the exception of alimony. If alimony is awarded, that is modifiable. You must be able to demonstrate that there is a material change in circumstances since the entry of the most recent custody or child support order. What is material change in circumstance? We don't have a ton of information. There's some case law. It's very subjective. We now have, as of October 1st, a little bit of direction in the statutes as to what constitutes a modification. Relocation is automatically a modification ground for physical custody and legal custody at this point in time. Back to physical custody and legal custody. There have always been factors that the court has to consider when making a physical or legal custody determination. They used to be housed in case law. As of October 1st, they are now in the statute. They are not identical to what the case law said. They are very similar, but they are not identical. They are Part of any case that was filed after October 1, they are binding on the court, the new factors. In my experience, anything that was pending before October 1, from my understanding from the courts, is they're going to consider both the pre-October 1 statutory case law factors, God bless you, and the post-October 1 statutory factors. Those are now housed in the new 9-201. The court must now, or may consider, sorry, not must, may consider, right, the stability and the foreseeable health and welfare of the child, frequent, regular, and continuing contact with the parents who can act in the child's best interest, whether and how parents who do not live together, which arguably are all parents in most instances, with limited exception, will share the rights and responsibilities of raising the child's relationship with each parent.
And even if they do live together, that should be.
Yeah, I think you might can see more nesting arrangements now, actually, with that new factor. Does anybody know what nesting is? Okay, I'll get there, but let me run through the factors first. The child's relationship with each parent, any siblings, I think that's going to become more important than it used to be. Other relatives and individuals who are or may become important in the child's life. As a step parent, I really love this factor, I have to tell you that. The child's physical and emotional security and protection from exposure to conflict and violence. The child's developmental needs, including physical safety, emotional security, positive self-image, interpersonal skills, and intellectual and cognitive growth. Yeah, these are some like really heavy factors. I mean, they put a lot of, yeah, I would be curious. I have not read the legislative history. I don't know if anybody has about what they are in the case law. The day-to-day needs of the child, education, socialization, culture, religion, food, shelter, clothing, mental and physical health. Definitely put a lot more weight on mental health.
You know what, I think it means a lot too, the change in society with sexuality.
Yeah, I agree with you.
Gender identity.
How to place the child's needs above the parent's need. I really love this one too.
Yes.
Protect the child from the negative effects of conflict between the parents. Maintaining the child's relationship with parents, siblings, and other relatives. That's kind of, or how to, this one's how to, not just that they have these important relationships, but how to ensure that any future half siblings, step siblings, those sorts of things, remain some level of importance. The age of the child, any military deployment of a parent and its effect on the parent-child relationship. I don't know how I feel about this. I have very mixed feelings about this.
I don't like it. I don't like it.
Yeah.
I think it punishes.
I agree.
I agree with you that there is, I think you're going, I'm not sure that was the intention.
I don't think it was the intention.
I think
but
it was a
think
poor choice of words.
Well, I think that would be really helpful for, to look at the legislative history for those types of situations. Sometimes you have to wave around the committee notes.
Yeah, I think you're gonna see that. And so I will be very candid to the mentees. We mentors don't have any experience in this world. We don't have a lot of, this is our experience and this is what you're likely to expect. Nobody knows. The court doesn't know, right? They've had what, 3 weeks worth of these factors.
Exactly.
Any prior court orders or agreements, that one is consistent. Each parent's role and task related to the child and how, if at all, those roles and tasks have changed. So think about the day-to-day caretaking. Who took the child to the doctor? Who took the child to the dentist? Who dropped everything and went to school when the child was ill?
But I don't love that one either.
I don't love that one either because
You could have had just very, defined roles in your relationship. And that doesn't mean the other party who never
Can't
went
do
to
it.
can't do it, just meant that you all had an agreement. That's what you were gonna do. So that one is another one of those gray areas that.
That's
And
especially
it's just
important
like-
for married couples, not so much
Separate. Yeah.
separate, but definitely for married couples. 'Cause my husband, he
I mean,
was a kid every day.
Yeah,
It was
mine.
yeah, I mean,
Just saying.
in our world, we can't drop everything a lot of times, right? As attorneys, my husband he'll come all the way home from DC to get me if he needs to. So I guess we'll see what that's gonna mean,
Every damn
right? I don't really know. The other component of it is, I see first, is, a lot of what we've always heard from the client is, well, he didn't make dinner. He didn't wash the dishes. He didn't do the laundry. Well, he didn't because he knew you would. That doesn't mean he's incapable.
Correct.
And I'm picking on moms because candidly, it's often a mom complaint. I hate to say it, but you know.
Never took the kid to the doctor.
Right.
That's the one I hear all the time.
Yeah.
And
Never had any interest. Like, no, you just.
especially with the decision making, but I have had to say to my client, but you wouldn't want it any other way. Like,
Right.
that's the way you wanted it.
Yeah,
No,
or
it's
that's, you know, it's just like well, she didn't go to work during the marriage. That's because that's what you two agreed on. You agreed that that role of staying at home as a parent was more important than any income she could have made. You know, that's always the argument when you have an alimony claim or a claim to retirement or whatever the case may be. I mean, I don't think I do agree with you that Erica, that one might also have a detrimental effect. The location of each parent's home as it relates to their ability to coordinate parenting time, schools, and activities. Location is very important in this area. You know, just because it's 15 miles as the crow flies doesn't, as everybody experienced this morning, doesn't mean it's not a 90-minute drive.
Or 2 hours.
Or or whatever the case may be. I mean, so that's certainly important. The parents' relationship with each other, including how they communicate with one another, whether they can co-parent without disrupting the child's social and school life. Do not put the school in the middle. Do not put the school in the middle. That is not their job to mediate. How the parents will resolve any disputes in the future without the need for court intervention, AKA they don't want you coming back. Use your PCs for those of us who know PCs. That is one of the primary purposes of PCs. Keep them out of the court. The child preference, if age appropriate, and lovely catch-all, any other factor the court wants to consider.
Is this in our packet? Or was that something?
It was emailed out. It's just the statute.
It's in the email.
Okay, all right, I haven't been on my email since I left.
Is that the statute or the rule?
This is
That's
this is statute 9201,
Okay.
the new statute.
And this
It's
is
in
what?
there. I added it.
October
The
1st,
modification one.
Yeah.
effective
And the
October
court
1st,
has
2025.
to, address each factor on the record, right?
Well, in theory, they should have been doing that before, ma'am. We have a lot less family law appeals if they had done their jobs before. This is just a reminder to the court, as you
Sarah,
pointed
that's
out, that they must go through every factor, including their catch-all factor, and explain in detail, either orally on the record or in writing. Also known as the Court of Appeals doesn't want to deal with us family law attorneys anymore.
What you
Wouldn't
help
that
them a
be the
lot of
case?
times too is when in your closing,
Yes.
you go down the fact.
Yeah, I mean, yes, you're absolutely
Good
right.
point.
When
Yeah.
you are running through close, I literally print a copy
Yeah,
of the statute.
That's why I said.
And I say, Your Honor, this is gonna be really boring, but I'm gonna help do your homework for you. I mean, I present it just like that. Because if I can make an argument for each one of them, I know that they're listening. I know that hopefully they're going to repeat what I just said back to me.
Yeah.
Right. And
Okay? That's
I was
the
just
way.
gonna say, like, before you go into trial, read these over and think about your evidence and like how it fits into each factor, so that when you get to closing.
I actually write my closing before the first
Yeah.
witness even gets on the stand, because
Yeah.
I know.
Right,
If
that's
you-
your
if
guide.
you've done your job, you should
Or
know
dear,
what the
I have an
evidence
offer
is going
for
to be.
you
You're
and
absolutely
press.
right. But Kurt, you were saying DSG, David Goldberg's listserv. He once put out, and I don't know if anybody has any access to this, it's like a 25-page document of all the things you should consider under the old factors under Taylor and Montgomery County. I'm happy to share it with anybody. Okay, so for the mentees, the old factors that are encompassed in, what is it, Taylor v.
Taylor v.
Taylor, Montgomery County
Taylor
versus
versus
Sanders.
Sanders.
Sorry, I had a brain fart and I was like melding the two together as I'm saying it. Those are the basis for many of these new statutory factors. This new statute supersedes that case law. However, I think it will direct us as family law attorneys as to some of the things the court is looking for from an evidentiary perspective. I have that if you Google Maryland child custody factors, I don't know if they've taken it off the judiciary website. Howard County had a 2-page document that summarized all of the case law. I have it, I saved it, it's my baby. And it tells you what all of the old case law was for each of these things. And if you, Jennifer, you email me, I'll send it. And then David, the DSG one too. If you tell me.
That's how you're supposed to.
David Goldberg, who is a very seasoned attorney out in Montgomery County, for as much as I gave Montgomery County crap. He is an incredibly intelligent family law attorney. He does a lot of mediation now. He's very intelligent, but he's very opinionated. I would
Yes.
say that about him.
Yeah, colorfully.
And he does retirement orders too. He's very knowledgeable in that area. He's pseudo-retired, but can't give it up like most of us, I imagine. He once, when I was a very baby attorney, and that's how old this document is, sent me like a 25-page document of like all these, well, what about this? What about this? What about this? Under each of the Taylor v. Taylor and Montgomery County versus Sanders factors that I always print out when I'm drafting my client's testimony and the opposing party's testimony, because it makes me think about what I need to prove to the court. So I'm happy to share that with everybody. I mean, I'm telling you, it is like 20 pages, single spaced. And I think it will be very applicable even to this. But I think when you are planning your discovery, when you are analyzing your client's discovery, when you are drafting testimony, you know, you need to be looking at the statute. You need to be looking at the prior case law. Again, prior case law not binding, but it gives you an insight as to what the court is going to think. And you can't teach an old dog new tricks. All the judges, all the magistrates are going to have those prior cases in their brains. Have any of the mentors been in court in the last 3 weeks and had any questions about the new factors?
No, they didn't raise any questions, but
Did you change how you tailored your evidence?
no.
Because it was a pre-October 1st case?
Yeah, because is it after filing after
Yes,
October 1st?
that's my
Oh,
understanding,
that's
is
my-
anything, but I will tell you in Anne Arundel County since this was signed by the governor, which was over the summer, if I remember correctly. As soon as it was signed, I started getting questions. Well, what about the new factors, counselor? What about the new factors, Ms. Zadjura? I think because they were starting to think about it, not because they recognized, like, I think they were very open, like, this is not binding on me, but tell me about it. Tell me what, you know, you're looking for. So I do think that's gonna be very interesting.
Would you send out the David Goldberg?
Yeah.
I'll get it
Yeah.
from Jessica, then I'll.
Oh, you'll put it there. Oh, you put it
Send her reminders, send this.
Yeah,
send
yeah,
that.
I don't mean to use you as my scribe,
No,
Jennifer,
please,
but if you send me an email.
Yes, I'm gonna do
So,
it.
I'm happy to do that. And in fact, I think he sent me like 100 documents. I'm happy to share all of them. I don't know if they're any relevant anymore, but I'm certainly happy to
So
share.
prior to October 21.
Yep.
October 1, 2025.
Yep.
We can rely on Taylor v. Taylor and Montgomery v. Sanders. I mean,
You rely on whatever the judge or the magistrate that you were before tells you, but that is my understanding of.
so
the law.
October 1st, 2025, anything filed after that date.
Correct.
That's
That I'm certain
accurate.
about.
Yes.
Okay.
The other one, just mush them all together.
So we go with our gut.
I mean, what I would
Yeah.
tell you is if I was preparing a case, this is what being so low, I don't have a lot coming down the pipeline. But if I was preparing a case for anything that has a trial after October 1, I would be prepared to present evidence on both.
I would mail
Just
them-
as a
I would mail them
CYA for
together.
I
myself.
would, I would as well.
That's what I'm gonna do, because I have one that was filed before, but the trial's not until next year, so I'm thinking.
And by then, they're gonna be so well versed in it that I think you should be prepared. You can never be over prepared,
Correct.
right? You can be under prepared. I think you should anticipate, especially after October 1, getting questions about these factors, even if your case was filed before. But it also makes you a better attorney because you're getting practice.
Okay.
That's my personal opinion. Please don't, I mean.
I agree.
Don't take what I say as the gospel, but I mean, that's my personal opinion. Why not try to get experience in this? What's the worst case scenario? Is the court says, well, I didn't consider this. Okay, I said 3 sentences. I didn't have to. So what?
Right, and it's the best interest of the child always.
Yes.
Yes.
And so that is the standard. I have not said that.
I mean, I
So the-
always rely on Taylor.
The thing that the court has to consider is what is in the best interest of the child or the children. We talked about this a little bit. The best interest of the child standard trumps everything. Okay? It absolutely trumps everything. If you have a default, so we talked a little bit about what happens if somebody doesn't file an answer. If you have a default
It
in
means
case because
nothing.
the defendant did not file an answer, or the opposing party really did not file an answer, and you show up at a trial, you should be prepared if there are minor children to be able to prove all of these factors, put on evidence about all of these factors. Okay? Because if that opposing party shows up, the court's gonna say, I don't care that they're in default. And default means, generally speaking, that they cannot put on any evidence.
I mean, even if they don't show up.
Even if they don't show up.
No, you're right. But like the hard part is when you have somebody that shows up and they have all of this information because you didn't do any discovery. You need to be prepared to demonstrate what's in the best interest of the child, which means you need to be prepared to put on evidence from your client, documents or testimony, right, that demonstrates all of these factors. Okay? I will be very candid with you. If the defendant or the other party shows up in a custody case, I'm asking for postponement. The likelihood is the court is going to, you don't think so? In my experience, they will often grant them if the other party is in default and they show up. Because you don't.
Baltimore County, do they grant postponements if you have a default on a custody hearing and the defendant shows up?
If the defendant asks for it.
I don't think.
No, not if the
Oh,
defendant asks for it.
I think if they come in with an attorney,
Yeah.
especially, and are like prepared to have a full-blown trial, like I ask for a postponement to preserve the record and for an extension of the discovery deadline or the setting of a discovery deadline in those particular instances, because I don't want a malpractice claim. I don't want a bar complaint because I didn't try. What's the worst case
In
scenario?
Baltimore City, I think you have to be like on a stretcher before they give you a postponement.
Oh, yeah,
so-
you have to show up at
You
4:30 in the
denied
afternoon.
even
Well, I
if
don't
you
practice in
have
Baltimore City.
consent.
What?
I don't practice in Baltimore
Got
City,
it,
Erica,
okay.
that's why. But I mean, in Anne Arundel County, it's not an unreasonable
Yes.
request. In Howard County, it's not an unreasonable request. In Carroll County, it's not an unreasonable request. And I think if you don't put the postponement request on the record, to preserve for appeal, I certainly think you should be protecting that. But again, the best interest of the child standard trumps everything. If they show up and it's just a property case, if they show up and it's just an alimony case, they don't get to testify. You better have your case law with you so you can argue that to the trial judge or the trial magistrate, because most of them don't realize that or forget that fact or don't understand. You know, it's our job to educate them, right, and advocate for our clients.
So are you saying that at trial, the party shows, the pro se party shows up, asking for stuff that they didn't plead?
Oh, yeah, in that instance too, yeah.
So I just had a trial 2 weeks ago with Judge DeSimone in Baltimore County, and I argued Lasco, and he granted and said, sorry, ma'am, you're not getting that. In another case, he actually was looking over the pleadings and realized after spending like 8 hours arguing for properties, like, wait a second, counselor, please show me where in your wherefore clause and your complaint does it grant you marital property, and basically blew the whole thing up and just said, I'm sorry, I can't grant it. You didn't ask for it.
Yeah.
I mean,
Because we were like counsels 2 and 3 each in the case, but at the last, on the day of trial. But Baltimore City, though, they'll bend over backwards, go in the hallway and settle this.
Yeah,
I'm like, I don't know whose authority.
Yeah.
Or I can't say that, but I mean, I'm saying there's, unfortunately, when you're a pro se litigant, you're the attorney in the room, sometimes it feels like the court basically allows the pro se litigant to get away with all kinds of things you as an attorney would probably be disbarred over.
You're not wrong. I don't disagree with you at all.
I don't disagree.
Yeah.
Also
I mean,
happens
but
in
it
Hartford
doesn't
County.
work on eggshells when you've got a pro se opponent.
Right, so you have to basically think about not what you've done wrong, it's what could go wrong
Yeah,
just
that's
because
the
there's a
hard
pro
part
se
about
litigant.
default, I think. I think that's the hardest part about default. People are like, well, they didn't answer, they don't get to say.
That doesn't mean it's gonna stick.
Yeah, I mean, I think the MVLS clients in those instances complain less, right? Because they see you being prepared, they see you doing work. It's your paying clients and defaults that are like, I don't want to pay you to prep for this. I don't want to pay you for the worst case scenario. Just so we're clear, you're gonna thank me when I've prepped this much. And what I told you might happen does happen, right? It's the I told you so moment.
So just to clarify, if you're the plaintiff's attorney and the pro se defendant shows up, you as the plaintiff's attorney would ask for a postponement?
Just so you can try to get out and get prepared for what, because you never really want to go into the courtroom knowing nothing from
About
the
the
other
other side's
side.
case, yeah.
Yeah, you want to try to know something if you can. I mean, but I've done it sometimes. I'm like, I don't care. My case is so I don't know.
Yeah,
It's like,
I mean,
but
again, it depends. You have to feel the situation
Yeah.
out, right? Like,
Yeah.
if the defendant gets there and you can tell he or she is not going to put up a big fight about whatever it is that you're going to say, or,
ready for you.
yeah, or ready, if they walk in and they don't have any paperwork in front of them and, they're just really laissez-faire, I think I worry about it less. You have to read the room. If they walk in with an attorney and it's a custody.
Oh, it's
Yeah, that's
postponement
the-
all day. That's a postponement.
That's the difference. If they show up with an attorney,
Is postponement.
definitely request a postponement.
Yeah, I mean,
But
there are times where I have walked in with a pro se opposing party and they come in with a stack of paperwork that they're gonna put in evidence. And I say, Your Honor, this is not, they're in default, which I understand in custody means that they get to put on evidence, but I have the right as.
So do you then request that it be put in for a scheduling conference and get discovery deadlines?
Yes.
So that's what you're asking. So it's
Yeah,
not
I-
more postponement, it would be more of
It's
a.
like, sometimes I ask if we can convert the default hearing to a scheduling
Right,
conference.
right.
And, which is functionally a postponement of the
Right.
default hearing, right? I mean, and I cover all my bases. I call it all of the things. I'm asking for all of
Well,
the things.
first of all-
You know, like, just to protect myself, because
Right.
if the court says no, I've protected my client on the record, right? You know, obviously, if it's just a property case or just an alimony case, I walk in with the case law that says they don't get to put on any evidence. You know, you run amok if it's, you know, maybe nobody's dealing with custody and we're dealing with child support, for example. That's a best interest standard again. The court has to put on evidence about child support. So, you know, I need documentation. I need proof of income and I need proof of expenses. So you know, I think it just depends on the situation. Go ahead, Curtis.
I make it a practice always to talk to the other side, like when you get to court, even if you know it's not going to lead anywhere, sometimes the judge is going to say, well, did you talk? Can you work this out? And if you say, oh, no, you know, the judge is going to be like, well, you're the attorney, do your job. So it just,
Need a bigger person.
it sets the tone. And then there's sort of before, when, you know, from the time the case starts, you know, you're in the case, you're the attorney. It's important to try to have at least it's better if you can talk to the other side if they're pro se and like, you know, hey, I think in their mind, maybe they're like, here, you know, we're in this kind of like trench warfare mode and you can kind of break that dynamic sometimes and help.
You have to be careful though, that they
Yeah.
don't start asking you legal advice. And
Oh,
sometimes I like
yeah.
straight up say to them, look, I'm not trying to be
Okay.
rude to you, but I
Yeah.
have, you know, I have ethics that I have to abide by. I cannot cross the line of something that might be construed as legal advice to you. And so me being evasive, me not answering your question is
Yeah.
not trying to be rude or dismissive in any fashion. Like sometimes if you're just candid with them about that component, it makes them a lot less defensive because it can come across as rude and dismissive, right? If me as the attorney for the other party isn't answering their questions.
Yeah.
I totally- They don't want to,
And
it's
you can
because they can't.
refer them to the Maryland Centers for Legal Assistance.
That's
where
what I do.
Jennifer,
Correct.
worked,
always do
and
that.
It's a great program. So it allows pro se litigants to anyone who's pro se, doesn't matter how much you make, can go in and meet with an attorney and get help in responding to a lawsuit.
Yeah.
Absolutely.
And just as a practice point for the mentees, in litigation, you just have to be prepared for everything. I mean, truthfully, I mean, you really have to be
You have to have a crystal
prepared
ball.
for any and everything to happen. You can go in there and it's gonna go this way. You can have it just how it's going to align, and you get in there and it just goes all the way left.
Goes off the rails.
Yeah, so you just really have to be prepared for everything. And that's why you just, again, want to continue to keep yourself up on rules, case law and things like that. And obviously, as a part of practicing law, you always want to try to familiarize yourself and be very familiar with the other side's case, but you just really, as a litigator, have to be prepared
And
for.
I think the good points made today were always know your case law. That's why I asked you the question on Taylor v. Taylor and Montgomery and the rules, because you've always got to be able to present those to the judge. And if you take that judge down the wrong path and he goes, I didn't look at that case, then you're not going to be speaking to the judge. So
The alternative is if they don't address them in their opinion, then you know you're really in trouble.
All right, we're gonna move it along a little bit
Yeah.
because we're at 5:12.
We don't have much.
We're probably gonna go till about 12:30. Does that work for everyone?
I don't have
To hang in, somebody gotta go?
I have to go.
Yeah, I do.
Okay.
If you need to leave, you need to leave. I'll be quick.
I'll be sending out the video as well as the audio to everyone in a couple of days. And you'll be able to, those of you who have to leave, will be able to hear it then. You know, I want to make one comment about the material change in circumstances. we get a lot of folks who want to modify their custody arrangements, and they there were things that are considered material and things that are not. And just as an example, I had one client who called me just a couple of days ago that said she wanted to modify her custody agreement because the opposing party who had the child for a couple of days has a problem with constipation. And so dad put the Miralax in the apple juice and the child traded it when he got to school. And therefore, this is a material change in circumstances. I said, no, it has to be way up.
You always know what's not a material change. You don't usually know what is a material change. I mean, I hate to say, that's like a terrible answer, right? But like, I can look at something and be like, that's not a material change. Is it a material change? It depends on the judge or the magistrate you get, right? Like, I mean, there's a lot of, overlap. This is something the courts always want to know, and I'm not trying to be rude to those who need to leave. I just want to make sure I move it along for those who are staying. What parent loves the child more than they hate the other parent? I mean, I think that's very important. I see a lot of attorneys in my experience that in discovery will say, well, what are 3 positives and negatives of the other parent and of yourself? I hate asking that question in discovery. There are very few questions I want to ask on the stand that I don't already know the answer to. That is always one of them, because the court will read the body language of the other parent and how long they hem and haw and how long it takes them to get an answer and how shitty of a response they can come up with and how they have to scrape the bottom of the barrel. And it demonstrates so much to the court. It is not even funny.
Yeah, I don't like it in the interrogatory.
I don't like it in the interrogatories. I want to ask it on the stand. I want to see your visceral reaction when you cannot think of something nice about your co-parent. Right? Okay. I think this should do both. Yes, it will. Can we go to the next slide?
Yeah.
Thank you. All right. All right. So physical custody, where the kids lay their heads at night. Shared is, my rule of thumb is anything that includes an overnight to the other parent. The definition of shared or joint physical custody for physical custody purposes is different than what the definition is for child support purposes. For child support purposes, it is now 25% of the overnights put you on a shared child support guideline scenario, which is like a little over 2 nights. So it's every other weekend pretty much, right? Under the fairly recent statute or the law change, you have to consider what is an age appropriate schedule and what the actual limitations of each parent are. If you have a parent who is a nurse in the emergency room and his or her schedule changes on a monthly basis, you have to craft your request to the court or whatever settlement terms you come up with as it relates to custody to take that into consideration. If you have if you have, not that long ago, I had one parent that was a firefighter that did 24 on, 48 off, and one parent that worked in the emergency room as a nurse overnight. And grandma from one side or the other often had the child overnight. And it's like, what do you do with this? What do you ask the court for? Because grandma can't have custody of this child, right? So that's when you really have to get creative into what your ask is to the court. There are a lot of standard schedules, for the lack of a better way to describe it, right? I mean, we're all very used to the old school every other weekend. Does that look like Friday through Sunday? Does that look like Friday to Monday? You have to explain to the court what it is that you're asking. And I would say you really need to handhold them. Spell it out. Tell them what time you want the exchanges to be. Tell them what day of the week you want the exchanges to be. Do not make these judges and these magistrates get creative. First off, everybody will be miserable because they have too many cases on their docket and they don't have time to deal with this. I mean, there is no nice way to say that, and they don't want to. Right? They don't want to have to spell all of this out. They want you to hand them the answer in a really pretty tied up package with a nice little bow on it. Okay. That includes the holidays. Okay. You want to alternate Thanksgiving. What does Thanksgiving mean? Is it Thanksgiving Day? Is it school dismissal on Wednesday through 9 a.m. on Friday morning? What does it mean? You have to define it. And the thing we all have to remember as practitioners is people don't like to be dictated to in their custody schedules. But you know what? It keeps them from coming back to us. It keeps them from coming back to the court. And what I always tell people is whatever is in your agreement, whatever is in your court order is the default if the two of you can't agree. Grandma's in town from Germany. Y'all need to work together and figure it out to deviate from this schedule because that's what's best for your kid this year. But if you can't agree, you know what the rules are. You know what everybody is playing by. You know what, everybody has to do what their expectations are. But you need to, when you're presenting this to the court, tie it up in a pretty little bow and tell them exactly what it is, okay?
Well, isn't that what like the parenting plan is for? Like,
That form is the worst court. form I have ever seen.
I hear, like, when I go to the
You're right.
little, bench bar meetings
right.
and like.
There is a law that says we have to fill out this form called the Joint Statement of Parties Concerning Decision-Making Authority and Parenting.
When people are-
9204.2.
Some people make their own, like have their own.
I
little
make my own
have
because
their
this
little
form is
templates.
terrible.
Yeah.
But the court knows this form is terrible, right? The court knows this form is terrible. And they are so used to listening to us as the attorneys. They want to hear from you. They don't want to have to look at this piece of paper that probably doesn't give them the detail. And when you file this, your ask to the court could change. Your ask to the court could change, right? So, I mean, you can't just rely on this, even though they want to file this. This is really great in MVLS cases. Let's be candid, right? With your parties who can get away with less detail in many instances. It's really great for your pro se litigants who need some sort of directive. For us as practitioners, I think you need to be crafting your own form. First off, I can't write all the things I need to write in this silly little 2-page court form, but there are often so many more nuances to a family law case that the document didn't contemplate that I would really encourage you, if anybody needs a template, I'll give you mine. I'm happy to. Mine are 15 pages long. I've literally written a parenting plan in grave detail and I've handed it to the court so that when I do get to court, I don't have to dictate. Here you go, Your Honor.
Jennifer.
Yeah, I'm happy to.
yeah.
I just take the terms of my parenting planner of my MSA and I dump it into my standard pro forma 9204 statement, okay? I mean, it's just a Word document. I copy and paste from my, model documents, my model orders, those sorts of things to put in there, because then I'm dictating to them, but I'm giving them a piece of paper. And it's not uncommon for them to say, okay, well, we're gonna read down plaintiff's side, or we're gonna read down defendant, do you know what I'm saying? So
Let me just tell you, making a point, I'm telling you, and I found so many, when I tell the judges exactly what I want,
you're more likely to get.
and the other side, I get exactly, I mean, when I tell you exactly, like, they take mine and they turn it into an order. I mean,
Or sometimes they'll say, counsel, can you write the order?
Yeah, I've got that.
You're right, Your Honor. I absolutely can. I'm a copy and paste my parenting plan.
Judge Veronica loves me every time.
I-
Knows it's gonna be.
Seriously, the more work you do, more heavy lifting you do for these judges and the magistrates, the more likely it is, in my experience, that your client is going to get what they want. Or more of it than the other side.
And in the high conflict cases, spelling it out is so good for your client too, because then there's not one more thing to fight about, which is, wait, what does Thanksgiving
They're gonna be
mean?
back.
So spelling it out is really key.
If you don't have it spelled out, the form that they have always makes me very queasy. I like a parenting plan with it all spelled out, so everybody knows what everybody's doing. And I've used them, as you said, it's the default agreement and it works.
I tell parties that all the time. Well, what if we don't want to do this? So don't do it. Put it in writing between the two of you, but don't do it. Like, nobody is going to big brother you once this court
Right.
case is closed, right? Whatever you guys can agree to, please do it. That's what's in your children's best interest. Magistrate,
100%.
now Judge Kramer in Howard County. She was a magistrate when I started practicing many years ago. And I very vividly remember when I was a very baby attorney walking into her courtroom and her saying to me, do not let your client pay you as an attorney to put your children through college.
Yes.
Right.
I am never going to love them as much as these parents love them. I'm never going to know this child in this 3 hours, 1 day, 4 days, whatever, however long this case is going to take. And no amount of fighting in my courtroom is going to make them parent better. The only thing that's going to make them parent better is if they go outside and they figure this out themselves. I repeat that to my clients 15 years later. Because she's not wrong. If you want to pay to put my kids through college, more power to you. But really, you guys should figure it out, because even though I've been with your case for 12, 15, 18 months, I also don't love your children. I might empathize with you. I might empathize with your children. I don't love them. I have my own children to love. Thank you. You can put mine through college. You can pay for my next vacation. You can do whatever it is you need to do. But that's not solving any of your problems. In fact, the parties in my experience who litigate never resolve their co-parenting conflict. Maybe not never, most often, right? Those are the parties who are coming back to you for the modification. Those are the parties who, when grandma is here from Germany, can't figure it out. And they're calling you screaming because they have no choice but to use the default, right? Like these are the parties who hate each other more than they love their children, right? Like that's the whole point of that, so. All right. There are some examples in the materials. I'm not going to run through them because we're running long about what various different 50-50 custody schedules are, but I would implore you to be creative, but think about the long-term ramifications, okay? If you have a 3-year-old and you're coming up with a custody schedule, you better assume, I don't like the word assume, please don't get me wrong, that custody schedule is going to stay in place for the next 15 years. There is no guarantee that a modification is ever going to be granted, which means whatever custody schedule you have crafted in your settlement agreement, in your parenting plan, in that court order is going to run from that time that child is 3 to the time they are 18. I don't know if you're all parents, if you know anything about children, what is good for them at 3 is sure as heck not good for them at 15 in most instances, right? So you really have to think about how this will logistically play out and how this agreement or these terms or whatever you're asking the court is going to grow with these children, okay? Legal custody, we didn't spend a lot of time talking about that. There are, again, factors that are commingled with the physical custody factors in the new statute. But again, you need to look at the case law to kind of give us an idea as to what is going to, what the court is looking for. You really have 3 options. Sole legal custody, which means one parent gets all of the decision-making power. In my experience, it's not a very common answer. If you have, one parent lives here in Maryland and another one in California, maybe it is appropriate in that particular instance. If there's a lot of domestic violence, sometimes you see sole legal custody being very appropriate. If there is, concerns regarding alienation, it might be appropriate. There's certainly limited circumstances, but the court really wants the parties to make joint decisions for their children. Your other options are just straight legal custody. That means 50-50. If they can't agree, they either go see Erica as the parent coordinator, if a parent coordinator has been appointed, or they go to mediation, or they go back to the courts and seek a modification of legal custody. Straight legal custody is great if the parties really can work together. It is
dreaded tiebreaker, hate it.
I have a love-hate relationship with tiebreaker. Some cases it's really appropriate. Some cases it's just weaponized, right? So your other alternative is the joint legal custody to the parties, but one parent has tiebreaker, which really means somebody has 51% of the vote. It's not uncommon in those instances that the court will put in terms as to when that tie-breaking parent can make a decision. Sometimes they don't. Those are the ones who are constantly with you and you are constantly modifying. Tiebreaker is defined in Santo. I think that definition and that kind of explanation and those factors, the things the court has to consider is really going to kind of continue forward when you're thinking about the presentation of your case. Thank you. Here, we talked about this. Challenge your client as if you're the opposing counsel or the judge. Good job. Don't read text messages between divorcing parties or separating parties. It's like the worst case scenario. It's like the bottom of the barrel of humanity. The judges hate it. The magistrates hate it. The attorneys hate it. I drink a lot of coffee reading text messages.
It's helpful to
it is
get to I think in the beginning as you're developing the case to get a flavor for what's going on, how they communicate.
And I agree with you, Sarah, because a lot of times your client will come in and just make you have the most sympathetic case and
correct.
Woe is me, and then you read the text and you're like,
it's like I was saying earlier about discovery, right? Please don't give me any preconceived notion about what your case looks like. I don't want you summarizing these text messages. I want you giving them to me in chronological order because I want to create my own assessment. Because if I've done my job as an attorney, I'm sitting you down and saying, you're going to do this differently and this differently and this differently and this differently. Stop talking. Please just stop talking. Please don't talk to this person, that person. Don't tell your grandma about what a terrible human being, whatever the case may be, right? Yeah. I mean, they are the bottom of the barrel.
Social media, be careful.
Oh yeah, don't go posting on social media. That's also terrible. Cardinal sins of custody. Don't put the kids in the middle. Don't hurt the children or the other parent. That can especially include emotionally, not just the obvious physically. Don't disparage the other parent. Don't talk badly about the other parent to the child, in front of the child, around the child, to other people. Anybody who's going to adopt it and potentially repeat those things to the child, right? Don't discuss the case with the children. Super important one. Don't withhold child support because the other parent is withholding access. What's good for the goose is not good for the gander, and two wrongs don't make a right. It's always nice to be able to say, well, my client continued to pay child support despite the bad behavior of the other parent. Don't interfere with Mother's Day and Father's Day. I would agree with that one. Don't introduce the kids to the new love interest. Obviously, there are some situations where this is appropriate. The way I phrase that one with my client is, before you do this potentially stupid thing, please talk to me about it. Because
at least wait until this is over.
It depends though, right? If mom and dad have been separated for 5 years and they're just now filing for divorce, like maybe I have a very different perspective. Maybe it's me. I'm a step parent. Like I'm harmful in the grand scheme of things, right? I mean, I have a good head on my shoulders, like those sorts of things. Maybe that person brings a lot to this child, to the table for the child, whatever the case may be. But again, every situation is different. If you had an affair and you moved out, and please do not, leave the paramour out of this. That's the big one. Leave the paramour out of this.
Right,
Always leave the paramour out of this. And whoever was cheated on, please don't bring up the paramour either and tell them that the other parent. Also that.
God's sake.
Relocation. That's probably a big no-no. People don't realize how damning that is. In an ideal world, my client would come to me before the parties separated, before they were no longer living in the same house together. Because if you move 45 minutes on the other side of town, rest assured, you're probably not getting a 50-50 custody schedule with traffic in this area. So let's have a conversation about what is reasonable, right? I get the financial limitations. This area is very expensive. There's also another one like divorce rules for parents in the materials. Child support, there are child support guidelines that are binding on the court. The mentors could probably spend hours discussing the recent case law that came out this summer, Hauser.
Oh, gosh.
I don't think it changed anything. I have a very different opinion. I think it just told the court that they should have been doing all of these things that they have not been doing.
Only Anne Arundel County does it.
That's how Anne Arundel County was doing it beforehand, and they got really mad when one of their own challenged them. It was a really ridiculous case. There is a recent case law that somebody tried to waive $2,500 a month in child support. Why they thought this was ever going to suffice, I don't really know, but that's not there. Child support is based on gross income. People get really angry about this. They don't get that money in their bank accounts every month. It is your before tax dollars. It is the absolute highest number of income that you earn. But that is what the legislature did, and that is what we are stuck with. There is a child support calculator. It is called Sassy Calc. There is also one on the DHR website that is free to use. Sassy Calc has an annual fee. It's not a very high fee. Do we have access to like a discounted rate for Sassy?
For who?
For Sassy Calc? Stuart,
I don't know.
I can't believe Stuart. I'll email Stuart and tell him MVLS.
County Law Library.
I will.
Yeah, that does make
Email
sense. You're right.
There's a family law attorney here in Maryland that actually created the app Sassy Calc that would, yes, Stuart,
For free in the law library, circuit court.
Yeah, yes, you can, absolutely. But the benefit is it's the same calculator that the judges and the magistrates use. You do need to file at the very bare minimum, a short form financial statement. Again, it's signed under oath, make sure your client's income and expenses are accurate. The obligor can be incarcerated. There are also certain expenses that are included in there, the health insurance cost for the children or the child. That is not the paying parent's obligation. So like if you have, when you pay health insurance, right, you pay an employee cost and then an employee plus one or employee plus family or whatever the case may be. Whatever cost that is directly attributable to the employee is not includable because that would be incurred regardless of whether they had children. People really don't seem to get that one.
No, they don't.
Work-related, necessary work-related daycare expenses, which include summer camp if you have elementary, middle school age children. Obviously, mom and dad still have to go to work when they're out of school during the summer. So those constitute work-related daycare. Extracurriculars are not usually includable. Uninsured medical expenses, known uninsured medical expenses. If a child has ongoing therapy expenses and one parent pays it, credit should be given for that. If they have regular allergy shots or whatever the case may be, something that is known and regular and consistent for that child. The modification standard is the same. There has to be a material change in circumstances, but what constitutes material is up for discussion. There have been some recent changes in the statute as it relates to child support, and I'm happy if you remind me, Jennifer, I'll circulate. I realized just now that I didn't put the new child support statute in here. There is now something called a multifamily adjustment. I'm not sure I know what this means either. I'm not really sure I know what this one means either. I
gotta learn by Fridays.
it's very confusing to me. So and mentors, please help me out on this one. So my understanding, it also went into effect on October 1, is that if there is a child to which either the payor parent or the recipient parent has a legal obligation to, because I think the statute specifically says legal obligation, they can get a decrease in their income for the calculation of child support, and there is a formula within a formula for the child in question of the case that you are handling. Hopefully that makes sense.
So basically,
And a legal obligation, I would think, so for example, if my husband and I have a daughter in common, my stepson lives in my house. If we were to get divorced, I could not get an adjustment for my stepson because I, as his step-parent, do not have a legal obligation to him.
dad can,
Yes,
when it comes to you and your.
correct,
No, but if you have another child,
correct.
but you don't have a court order for that child support for that.
It can
child.
now be included. It used to be, under the old version of law, that there had to be an order for child support.
That was being paid.
That was,
Yeah.
that's the caveat, that was
Right, it was
being paid.
paid, right,
Um,
or evidence it was.
but that is no longer the case, and there are all of these really random, like, exceptions and discretionary components of the new statute that it's like, we're operating in the wild, wild west.
Yeah, because
So, I don't-
a legal obligation, you have a legal obligation until you've been somehow, your parental rights have been terminated, right?
the child emancipates, yeah.
Yeah, so you have a legal, but that doesn't mean that you're.
But they don't have to give you credit for that child, which is very weird. It's not a shall, it is a may, is my understanding in reading the statute. So child support is a little
So
rogue
now we
right
have to
now.
bring in baby mamas to say.
Child support is a little rogue right now. So is custody,
Give me a
but more rogue. Okay, contempt. Contempt is if there has been a violation of a court order potentially, or an alleged violation of a court order. The underlying court order, which can include the incorporation of agreement, either a settlement agreement or a parenting plan, must be clear, meaning the alleged contemptor must know what he or she did or was obligated to do in order to be able to violate it. So reasonable and liberal visitation to dad doesn't help the court from a contempt perspective, because everybody's definition of what reasonable and liberal is subjective. So this is another really important reason as to why your physical and legal custody provision should be detailed, because otherwise you run amok if you don't know what you are enforcing. There's a recent case regarding purge provisions. That's Brianna C. versus, thank you, Rodney D. Thank you. I would highly encourage you to read that. There is also in your handout some information from Howard County Circuit Court that the judges and magistrates put on a presentation about your contempt checklist that came out since Brianna C.
So is there an actual case now that says that there has to be defined terms?
I think there's always been case law that says that. I don't, those are my words, but that's the gist of the case law, yeah. I think if you read Brianna C, it cites the history of contempt pretty clearly, is my recollection. I will be very candid with you. I will file a motion to enforce 10 times over before I file contempt.
Oh, yeah, I don't.
Because the magistrates and the judges don't know what to do with contempt anymore, post Brianna.
And
See?
you would go to court on a contempt and the other side doesn't define what the purge or sanction would be. I've had magistrates dismiss the
Correct.
contempt because when the council says, whatever your honor feels is necessary.
That's not.
That's not an answer.
Doesn't
So I
work.
had Paley in Baltimore County to say, look at opposing counsel, say, nope, that doesn't work that way. I'm not,
Yeah.
I can't
You
do
have
it.
to tell me what it is, and the purge cannot be complying with the terms of the
And it's a
order.
notice requirement, right?
The purge cannot be the same as the alleged violation. Sanctions can include, attorney's fees, those sorts of things. I think that's the last slide. Attorney's fees. Everybody pays their own way unless there is some sort of statute that applies. There are several in family law. There's ones for custody, child support, visitation, divorce, and marital property and alimony. Each one has their own statute. Please read it. It's very important. They are very similar. There are some nuances that are different, okay? You can also, if you look at 9105, if there's been an unjustifiable interference with visitation, you can get attorney's fees in that instance as well. If there is a BIA, a best interest attorney, and we'll talk more about that at a future presentation, the parties can each be ordered to contribute, or one party can be ordered to contribute to that as well. There's also 1-341, which is bad faith attorney's fees, which can be assessed against a party, even if that party's attorney acted in bad faith, and the attorney can be sanctioned under that one as well.
And if you're gonna go for attorney's fees, there's rules about keeping track of your time, and if you ask for more than $500, you have to give the customary legal, anyway, it's sort of like.
Yeah, if you
a
need.
big pain to comply with requesting for.
Yeah, if you need an affidavit in support of fees, which I always file the night before trial when I'm done with all of my trial prep. I will have provided my bills up to that point, but I always follow the affidavit as like the last thing. You can put that. I have a weird feeling. I don't like affidavits. I think it creates you as a witness in a case.
Technically, the proper way would be to bring a colleague into court
Correct.
to then review your bill and do that.
Which is-
We're usually.
Overkill, and the statute allows you to file this affidavit, but it's very weird to me. Like every time I do it, I think, I don't know that this is really the proper method.
12103C, like good cause has been defined
Yes,
recently by
correct.
my firm worked on, well, I worked on that.
Yeah,
appeal.
yes, you're right. It has. Good cause has.
Was that
And that was
And-
a big judgment.
in Montgomery County?
Yeah, like, I think it's like over $600,000
Yeah.
for lack of substantial
And
justification.
I don't know if you went over this already, but
I talked really fast, so it's possible, or it's possible I didn't,
I
sorry.
just wanna just figure this out, and I can't figure this out during law school. So like, what exactly is a sanction? Like,
It's a penalty, for lack of.
so like, so that scares me. So I'm like, what do you mean by like penalty? Is it like you have to pay expenses to the court, like?
Or to the other party,
To the other
oftentimes,
party.
or if you deny visitation and access to a child, it can be make-up time, for example.
Okay.
Those are really your two big ones, I think, in family law.
Legally fine.
Yeah, I mean,
Fine,
sometimes
fine,
like the
fine.
agreement or the court order will define what the sanctions are. Like when we draft settlement agreements, it's not uncommon if somebody tries to relocate with a child that there's sanctions in that particular paragraph specific for that instance. I have drafted agreements where like pre and post nuptial agreements, and we're kind of going down the weeds a little bit, that if somebody tries to set aside the prenuptial agreement as invalid for some reason or unenforceable for some reason, that, the other side is entitled to attorney's fees in those sorts of instances. So sometimes the document controls what the sanction might be. If you look at the contempt statutes, they will also tell you, and the case law that supports it, what the sanctions can be in some
For
instances.
discovery too.
Yeah, and discovery also has different sanctions, like you can be in discovery, if you file a motion to compel and for sanctions, somebody can be precluded from putting on certain evidence, from bringing an expert witness, for having to pay attorney's fees for being chased after in discovery if there's discovery violations. I'm trying to think of, yeah, those are your real big ones in discovery too.
And like so, what's kind of what's an estimate of the sanctions? Like, let's say you get a new attorney, like, in like a family law case, new attorney forgets to meet the discovery deadline, sanctions get issued, how much are you talking, like, in money of that?
Oftentimes it's tied to the actual attorney's fees incurred. by the other party and having to seek the discovery or go after that party. Discovery, I mean, there might be a sanction to the attorney from the client in that particular scenario, but
But one thing you have to keep in mind, other than the 12103C, where it talks about finances do not matter, which is a very specific sanction. You have, there's many times when I can get an award. There's really a two-part test. One is the need, or there was definitely bad faith, or you can win the counsel fees. The hard part is proving the ability to pay of the other party, because more often than not, that's the case where no financial statement was ever filed, no financial information was ever provided, even during discovery, and you put on no evidence showing that they actually have money or the ability to pay whatever the sanction might be. It's only when that's super bad faith or they're in such contempt that the court feels that that you basically have proven it was so egregious that it doesn't even matter if the client can afford it or not, that they'll award that. Those are very rare.
so keep in mind that you have to prove what the other party's ability to pay your attorney's fees are, which candidly increase the sanction potentially if they haven't done what they were supposed to.
You have to be reasonably justified that you had to defend the case, which is why you want counsel fees. But unfortunately, until you can actually show that they had the ability to pay it, you're screwed.
Right. And which is the annoying thing that Montgomery County does is like whenever someone asks for attorney's fees, usually at the scheduling conference, they will like order both parties to file the long form financial statement, although the statute doesn't require that. Like it's just something Montgomery County is kind of.
No, Anne Arundel County does it too. I mean, I think if you actually read the case law, though, there is some, I don't think it's a requirement, but there is some explanation from the court in some of the case law that long form financial statement really supports the notion that somebody can or cannot pay it because they've signed the document under oath. So it's not uncommon in that particular instance. The thing about bad faith attorney's fees, I kind of look at this as just don't be a jerk. Act as though you want, in a case is in the manner in which you would also want to be treated. And, there's a reasonableness standard, right? I mean, if somebody's just litigating to litigate, that, is arguably bad faith, especially if there's evidence to the contrary. So I don't think that's awarded, not as much as people request it. All right, good luck. Here we go. That's what we got.
Real quick, before we close, I want to just mention a couple of things. Again, this will all be sent out to mentors and mentees and probably about, I don't know, give me a week, give us a week to get that out. I won't be here.
I'll do it.
She'll do it.
Yes.
The other thing I wanted to mention to you all, and we will send this again in an email, the mentees, number one, while you're working on a MVLS case, will be covered by our malpractice insurance for free. Okay, that's just a benefit. I also want to let you know that, and I'll send this out also because there's a link to it. You'll all have to sign up as volunteer attorneys before you can take a case so that we have you in our system. I'll make sure you have that. Let's see. What else? I'll send you a link to the external collaboration that I spoke of earlier. And I want to check to see if you're eligible as mentees for a discount on Westlaw. It's a discount, so you would pay for it. So you may not want that.
So MSBA has Decisis.
And they have Decisis, which is free.
Correct. If you are an MSBA member, you get Decisis. You have to log into your MSBA account, but it's similar to Westlaw and LexisNexis.
Yeah.
One provides more.
It's like, I talked to, that's what they said on Friday.
What?
That the Decisis is through LexisNexis.
Oh, is it?
Yeah.
I missed that part.
Oh, is it?
Maybe that was where I blew it off, Rich. Sorry.
Sorry.
So thank you all for coming. I hope it was for me.
Yes, and a big thank you to Jessica.
Try to cram in a session like this.
If anybody has any questions, please feel free to email me. Please don't be offended if it takes me a day or two to get back to you, but I promise I will get back to you. It might be at 3 a.m.
She always does.
Yeah.
She always gets
But it might
back
be at
to
3 a.m. Sometimes that's what I remember.
Yeah.
So.
Thank you, everybody, for coming.
Jessica, I did change the thing and then I clicked on the wrong presentation.
Anytime. And if I don't know the answer, I will.
Well, maybe, but I think I clicked on the one you sent. Anyway, you did.
Any questions? And it was so nice.
Well,
I didn't, what are we talking about except in February?
that I have to ask Nancy because I don't know the plan yet, but I will ask.
Last time we talked about DBA and something else.
Oh, maybe BIA said that. Oh, okay. Just make sure that I find out. And listen,
I have time.
I'm gonna end the webinar.
When you have a case.
Yeah, do you want to go lunch?